wasn't sure if
From the nation's capital, this is C-SPAN 2, a cable satellite public affairs network. In just a few moments, we'll begin our primetime coverage of the confirmation hearings for Supreme Court nominee Clarence Thomas. Today, in the Russell Office Building on Capitol Hill, the Senate Judiciary Committee sat through Day 5 of the Thomas confirmation proceedings. The Judiciary Committee is the panel charged with making the initial recommendation on whether Judge Thomas should fill
early
the Supreme
C-SPAN
Court seat
used to
vacated by
enjoy
retiring Justice Thurgood Marshall.
the B-roll,
As
you know, just
previously
people hanging
promised
out.
by Judiciary Committee Chairman Joseph Biden, this was the final day of testimony for Judge Thomas.
Is that
During the
right?
hearing, members examined his views on, among other things, the Voting Rights Act and his tenure as chairman of the Equal Employment Opportunities Commission. At the conclusion of Judge Thomas' testimony, the Senate panel heard from
process seriously.
Oh,
All
all right, hold on. We don't want to miss anything good here. Here we go, gavel down.
The hearing will come to order. Welcome back, Judge. It's a pleasure to have you back. As I said, I expect this will be our last day to hang out in this room together. I know things are moving along, and you've begun to take this process seriously, because I've now met your 8th grade nun. She's here today, which means that we better end it. I assume that's why you have her here, is just in the event that somehow we couldn't finish, she would remind me of the fact I said on Friday we were going to finish. So I assure you we have an added incentive to finish today. With that, why don't we get right to the order of questioning, Judge. And again, any time that you would think it's appropriate to take a break, we'll do so. And I think what we should do is sort of play it by ear as to when we have lunch. If it looks like, because I'd like to finish before lunch, and lunch, that may mean 12, that may mean 1. But let's make that judgment as we go, if that's all right with you. Okay? All right. The next questioner. I don't know what round it is. Yeah, we're starting. Okay, who's
Is this the third round?
Yeah. All right, it is now.
Call me in, I'll explain it. We don't have any else.
All right, the way where we are now is the next questioner will be the most senior Republican who has any questions, and I yield to Senator Thurman if he has any.
Mr. Chairman, I have no more questions, and none on our side have any, except distinguished senator from Pennsylvania. I believe he cares for a third round. Senator Grassley, did you have any questions on the third round?
I have used 6 or 7 minutes of the third round. Don't anticipate maybe using any more unless something happens.
So you have no more this time. Well, then, distinguished senator from Pennsylvania.
We yield to the senator from Pennsylvania.
I thank the chair. Judge Thomas, if you are confirmed and you join the current revisionist Supreme Court, and I call it a revisionist Supreme Court as opposed to a conservative court, because the current court has gone beyond the conservative judgments illustrative the unanimous opinion of Chief Justice Berger in the Griggs Court, and is a revisionist court now, I think. I would ask if you would be philosophically attuned more to the Justice O'Connor line or the Justice Scalia line, and I will deal with 2 cases for illustrative purposes. When I had finished my questioning, my time ran out on the second round. I had been asking you about Rust versus Sullivan. And in Rust versus Sullivan, Justice O'Connor dissented. That was the case where you had a regulation by the Department of Health and Human Services, which had stood from 1971 to 1988, and then it was changed, and the Supreme Court upheld its change on a variety of grounds, which I had specified in my last round, but the one which struck me the most peculiarly was the ground that it is appropriate to change a regulation when it is in accord with the shift in attitude. And that had related to, in part, to your compliment of Justice Scalia in your Creighton speech, where he had referred to this First Amendment concern. And I would ask whether you would side with the O'Connor branch or the Scalia branch of the revisionist court.
Senator, without reference to Russ, I think, as I attempted to explain when we addressed this last week, Chevron versus USA involved an instance in which EPA changed its regulation, an existing regulation concerning the bubble concept. That was a concept that was hotly contested, and EPA had adopted a regulation rejecting the bubble concept, as I remember it. Subsequent to that, EPA revisited the concept and adopted it. And the question was whether or not this new regulation was a reasonable interpretation of EPA's underlying statute, or the statute in that case. And the court held that it was indeed, and upheld the regulation. That is generally the existing law with respect to deference to agencies' reasonable interpretations in the administrative law area. Whether or not that is easily transported to the difficult case that you've just mentioned, or is easily reducible to an instance in which there seems to be just a change in, as you say, shifts of attitudes, and whether shifts of attitudes would constitute a reasonable basis for making such a change, or that shift in attitude comports with a reasonable interpretation of the underlying statute is, I think, a totally different question. But the point that I'm making is simply that the Supreme Court has permitted, in the leading case in the administrative law area, has permitted there to be a change of regulations by the agency, even when the existing regulation had been in place for some time.
Judge Thomas, in Russ versus Sullivan, the court concluded that the regulation was acceptable, saying that, quote, the regulations simply ensure that appropriate funds are not used for activities, including speech, that are outside the federal program scope. That ruling gives me enormous concern. It's given many, many people in this country enormous concern in light of the very extensive federal rule on funding, so that if you have a federal program which is funding a given activity, and you say that no one can speak in opposition to that program, there is an enormous latitude for restricting freedom of speech. And my question to you is, do you think that it is appropriate, when there is federal funding involved, to limit speech when that speech is outside the federal program scope?
Senator, I think that in this case, with respect to the question, the underlying question in Russ v. Sullivan, that I think it would be, from my standpoint, moving too far to comment on the underlying issues. As I've indicated in other instances, Senator, in these difficult cases, and it's important to me that I not compromise my impartiality should cases of this nature and similar cases be considered by the Supreme Court in the future, if I'm, of course, fortunate to be confirmed.
But Judge Thomas, I'm not asking you about any specific issue, let alone any specific case. I'm asking you about a very broad philosophical question. It's as broad as the areas of federal funding, which are gigantic, and it's as broad as the First Amendment freedom of speech, which we hope even exceeds the breadth of federal funding. And the issue is, just because the federal government gets into funding and establishes the scope of a program, and I'm not talking about any specific issue, doesn't that give you at least some concern about limitations on speech, if you can curtail speech where federal funding is involved?
I think, as I suggested last week, Senator, I was very concerned in instances in which it appears, or in instances in which regulations by the government curtail our fundamental freedoms, and in this case, freedom of speech. I share that concern. What I'm attempting to avoid is offering a judgment on an agreement with a point of view on a very hotly contested and difficult case that could certainly come before the court again.
Well, Judge, I'm really beyond the case, but I will not press it further. Let me move on with my question to you about the revisionist court, and if you join, whether you'll be on the Scalia branch or the O'Connor branch, and go back to Johnson versus Santa Clara. And Judge O'Connor takes Justice O'Connor takes Justice Scalia to task for his dissent, which he says is an academic discussion. And then I think in a very important doctrinal view says that Justice Scalia's dissent rejects the court's precedents and addresses the question of how Title VII should be interpreted as if the court were writing on a clean slate, close quote. You have already stated that you believe that constitutional interpretation is a moving body depending on the tradition and customs of our society without being rigidly controlled by original intent. And here you have Justice Scalia taking Title VII, as Justice O'Connor says, writing on a clean slate, and Justice O'Connor rejects that and says that we have to take into account the court's precedents. And my question to you, would you choose a preference between the approaches between Justice O'Connor and Justice Scalia on that issue?
Senator, I think it is important for any judge to take into account, even when he or she disagrees with a particular case, to recognize that there is the additional burden and additional question of whether or not this case should be overruled. That is a question about the doctrine of stare decisis. I do not think that judges should assume simply because judges should assume simply because they disagree with a particular case that we're operating as though there was no prior case law or there no precedent, and feel free to act as though they're not in any way controlled or restrained or constrained by prior case law. My sentiments, without expressing a particular judgment on that case, my sentiments would be toward a preference for recognizing that there is significant weight to be given to existing case law, and that the burden is on the judge who wants to change that precedent to not only show why it's wrong, but why stare decisis should not apply.
Thank you. I'm going to store that one for Justice O'Connor, which may make it 1-to-1. Let me move on to the war powers issue, Judge Thomas, a question which is not yet been broached, and one that I think is enormously important, one which you and I had discussed in the informal session which we had before the hearing started. We have just seen an historic event in the course of the past year with the Gulf War and the vote by the Congress authorizing the President to use force in the Gulf War. In your writings, you have been concerned about congressional activity in many areas. And in your speech at Brandeis University on April 8, 1988, you said, quote, "In many areas of public policy, including foreign policy making, members of Congress can thwart or substitute their will for that of the executive." And you focus on foreign policy. You have been very critical of the Congress, as I had commented earlier, noting that there is little deliberation and even less wisdom in the manner in which the legislative branch conducts its business. And in your speech on September 3, 1987 at the American Political Science Association, you quoted with approval a statement by Gary Jacobson that in Congress there is great individual responsiveness, equally great collective irresponsibility. There are many issues where there is a confrontation between the President and the Congress, which we all know. And I would like your views as to the authority of the Congress under its constitutional exclusive responsibility to declare war, as opposed to the President's authority as Commander-in-Chief, which is a very central issue, was a central issue earlier this year. And let me start with a question that I told you I was going to ask you, and that is whether the Korean conflict was in fact a war.
Senator, I, in response to our informal discussions, did attempt to resolve an issue that scholars and political scientists, lawyers seem to have been debating for the last 40 years. And I recognize, I believe, as I indicated to you, that the hostilities in Korea and the President's response, of course, I don't think that there was a suggestion that the President could not respond. But your question at the time went to whether or not there should have been a declaration of war.
Correct.
And the short answer to that is, from my standpoint, is I don't know. I've attempted to look at that question, but again, it's one that scholars haven't resolved and that legal minds haven't been able to resolve. And I think that I would be imprudent to attempt to resolve it in this environment.
Well, Judge Thomas, when I asked you the question in our informal session as whether the Korean conflict was a war, you said you'd asked that question of Judge Souter, and I said that's right. And he ducked, and then I said, well, let me give you the weekend. He came back and he said, I don't know. Now, I thought that was okay under those circumstances where it was from Friday to Monday, but you and I talked about this on August 1st, and now it's September 16th. And I don't think that the Korean incident is going to be repeated. It's not asking you to comment on a pending case, and it's well established historically as to what happened. And this is a crucial issue as to whether American troops are going to be committed to combat on the President's word alone as Commander-in-Chief, or whether it's going to require a congressional declaration of war. So to the extent that I can push it just a little bit, let me repeat the question. Was it a war?
Senator, this isn't one of the instances in which I'm saying that the issue of whether or not the the hostilities in Korea was a war would be coming before the court. This is an instance when, as I've indicated to you, I simply don't know.
Well, let me try again. Instead of moving to an easier question, I'll move to a harder one. In early January of this year, there was a lot of debate as to whether the president had the authority to commit troops in the Gulf War without a resolution. President Bush asserted he did. And this Judiciary Committee held hearings in early January, and some even suggested, I think ridiculously, that the president would be impeached if he moved ahead without waiting for a congressional resolution. I thought it was ridiculous because Congress had sat on its hands for months and had allowed the United Nations to set a date for the use of force, January 15th, and finally Congress started some discussions on January 10th and moved on January the 12th. I'm not going to ask you whether you think the Constitution required congressional action or the president had the sole authority to act as commander-in-chief, because if you won't answer the Korea question, you're not going to answer that one. So let me ask you instead, what would the considerations be that you would work through in approaching that kind of a legal issue?
I think it's a very difficult issue, Senator. I have not addressed whether or not in the War Powers Act resolution, of course, is very complex and has a variety of reporting provisions as well as the more difficult provision involving the withdrawal of troops. I think that as I think I may have alluded to in our conversation earlier in private, that the whole issue of what the president's authority is as opposed to the authority of Congress seems to be one that is more amenable to the kind of process that this body and the executive went through or engaged in the Persian Gulf conflict. That is one in which the conflict is resolved in the political context. I don't think there's certainly not very much in the way of judicial precedent or judicial consideration of this particular issue. And as I've noted before, there's an ongoing debate among scholars on both sides of the issue. And I, for one, just as I have viewed the issue, as I've looked at it, it seems to be one of those instances in which the differences, particularly when there's an existing conflict, are better worked out in cooperation between the executive and the legislative branches.
Well, Judge Thomas, I agree with you totally that it's better to work them out, but that issue could come before the court. And a concern which I have expressed is your statements suggesting a lack of wisdom in the Congress. And I know you have already said that you will be fair and impartial, and that what you had said in the past was as an advocate as opposed to where you stand as a judge. So I don't think there's any use in pursuing that one any further. Let me turn to a specific case which you have decided, Judge. Although you did not write the opinion, it's a case of some significance involving the United States versus Jose Lopez. And it is a case which involves the interpretation of socioeconomic status under the Uniform Sentencing Guidelines, which have been enacted to try to bring uniformity on sentences in criminal cases. And those guidelines say that socioeconomic status should not be considered on the sentencing issue. And the facts in this case were very compelling about Mr. Lopez in terms of his own background, where, as the opinion of the court said, the tragic circumstances involved the death of his mother by his stepfather murdering her, his own threats that he had to leave town to avoid problems, his growing up in the slums of New York and Puerto Rico, and of not fitting in because of his dual background. The United States attorney prosecuting the case on behalf of the government and asking for a tough sentence argued that, and this is also from the opinion, quote, the government urges that a focus on particular life experiences would permit every defendant to distinguish himself from all others unless would undermine the purpose of the uniformity of sentencing procedures. You were on the panel which upheld an expansion of the sentencing guidelines which prohibited considering socioeconomic circumstances. And my question to you is, how far do you think it is appropriate to go in that line? And was the United States attorney prosecuting the case and asking for a tough sentence really totally wrong in the concern expressed that it would permit every defendant to distinguish himself from all others and thus undermine the purposes of uniformity in the guidelines?
The concern, as you indicated, Senator, I didn't write the opinions, and
but you joined in the opinion.
I joined in the opinion. After a while, you learn that when you don't write, after about 150 or 200 of these cases, they're a little hard to recall. But this case was a difficult case. It's one that took into account the notion or the concern that this body had that sentences be uniform, that there not be wide disparities in sentences. At the same time, the question was, when there is an individual such as Mr. Lopez, who has had very difficult and traumatic circumstances in his or her life, is this a factor that is not socioeconomic? Is it, even though it may have resulted from socioeconomic status, that is where he lived, are these factors that should be considered? And I think what the court did in that case, and I haven't had an opportunity to review that opinion, is to wrestle with that difficult issue, but also to recognize that there was in the uniform guidelines a prohibition against considering socioeconomic status. And I think ultimately feeling compelled to comply with that requirement.
Judge Thomas, the issue of the death penalty has not arisen in these proceedings except for one reference earlier to federal court habeas corpus, but that is a very important subject. There are deep-seated differences of opinion on the matter. I was a district attorney of Philadelphia for many years and believe the death penalty is a deterrent. Philosophically, is there anything about the application of the death penalty which would bother you from upholding it if confirmed for the Supreme Court?
Philosophically, Senator, there is nothing that would bother me personally about upholding it in appropriate cases. My concern, of course, would always be that we provide all of the available protections and accord all of the protections available to a criminal defendant who is exposed to or sentenced to the death penalty.
Well, since Furman versus Georgia, there have been elaborate circumstances set up for consideration of all the mitigating circumstances, but there has been a concern beyond the imposition of the death penalty in terms of it's not violating the Eighth Amendment to cruel and unusual punishment, and I frankly am pleased to hear your answer that you would support it in the appropriate case. There's been another concern about tremendous delay, some cases as long as 17 years, an average of 8.5 years. And there are proposals pending, which I have authored, which would set time limits within the federal system to give an opportunity in the federal court for a full hearing, but to make it a priority case because it is really watched by so many people as to whether law enforcement is really serious in carrying out penalties. And one of the legislative provisions calls for a time limit in the Supreme Court to decide these matters within 90 days unless the case is so unusual that it requires an extension of time, in which event the court could take longer on a stated reason. But I have two questions for you. One is, and people said this was too much for Congress to do because the court didn't sit in the summertime, And the response to that was, well, the court could sit in the summertime like other courts do. And my question to you is, do you think that Congress has the authority to establish a timetable as we have under the Speedy Trial Act, for example? And secondly, to try to abbreviate it, whether 90 days is a reasonable time, or if not, what time limit would be?
Of course, there is precedent, as you've alluded to, Senator, for establishing time frames. Whether or not Congress has the authority to do it in this particular case, I have not had an opportunity to think about. But Congress certainly has established time frames in a procedural way that governs the way federal courts at the district court level. It's certainly in our rules of civil procedure that govern the way that we do business. The Speedy Trial Act, I think, is the best example, the one best example. The question as to whether or not 90 days is the appropriate time, I don't know. My concern would be this. I know that there is the attitude and that we must move on, that you must clear these cases from the docket. We feel that way. We certainly feel that pressure as judges. But I think that there can be instances in which 90 days is not enough. There can be instances in which it may take more time to assure oneself that a particular defendant has been accorded all of his or her rights. I would be reluctant to say that I would endorse a particular cookie-cutter approach, but at the same time, I have no alternative to offer as to what is an appropriate length of time. But my concern would always be that we do not put ourselves in a position of adopting an approach that would ultimately in some way curtail the rights of the criminal defendant.
Moving Judge Thomas to the Voting Rights Act, you have criticized Supreme Court decisions there and have, as noted in your Wake Forest speech back on April 18th, 1988, referred to the individual right to vote as opposed to protecting some ethnic group with sufficient clout. But the Voting Rights Act has been very carefully tailored to try to provide that there is organization of voting districts so that a specific group does have some clout as opposed to a large representation or a configuration which did not deny a group of some meaningful participation in the electoral process. And my question to you is, don't you think that aside from the generalization of individualism, that there is some very important objective to be reached through the Voting Act to have a group with an adequate, meaningful participation in the political process?
Yes, I agree with that, Senator. My concern, I think when I wrote that, the speech is on individual rights versus group rights, I believe. And that was a one-paragraph example. I was using this general example, and it's the general concern that I've had throughout my speeches, and that is that in according group rights, that you don't overlook individual rights. I loosely, I think, referred to the voting rights cases, but the debate that I was referring to was this school of thought when I remember in the early 80s there was some suggestion and some feeling that the Supreme Court cases prior to the amendments of the Voting Rights Act required proportional representation. And of course there were denials to that, but there was that school of thought. My attitude was that if indeed there is proportional representation, that presupposes, I think that's the word I used in that speech, that presupposes that all minorities would vote alike or all minorities thought alike, and that's something that those kinds of stereotypes are matters that I have felt in the past were and continue to feel are objectionable.
Thank you, Judge Thomas. I know my time is up, Mr. Chairman. Thank you.
Thank you very much, Senator. Our next questioner would be Senator Kennedy, but I understand he is prepared to yield to Senator Metzenbaum because Senator Metzenbaum is also required to be at the Gates hearing in question there. Is that correct?
Thank you, Mr. Chairman, and thank you, Senator Kennedy. Good morning, Judge Thomas. It's nice to see you again. Judge Thomas, your testimony before this committee has touched upon the subject of economic rights several times. This is an area of concern because over 50 years ago, the Supreme Court used economic rights arguments to strike down laws that were designed to protect workers' rights and establish a minimum wage. In a 1987 speech to the business law section of the American Bar Association, you stated that, quote, "The entire Constitution is a Bill of Rights and economic rights are protected as much as any other rights," end of quote. You also stated that, quote, "Legislative initiatives such as the minimum wage and Davis-Bacon provided barriers against black Americans entering the labor force." You went on to say it is amazing just how little attention has been paid to these outright denials of economic liberties. Frankly, Judge Thomas, I am amazed to hear you say that legislative initiatives such as the minimum wage provided a barrier against black Americans. I would say percentage-wise, my opinion, I don't have the statistical data, but I would guess that percentage-wise, no group of Americans benefited more from the fact that employers could not pay them less than 30 and 35 cents an hour. And of course, it has gone up since that time. But Judge Thomas, in this 1987 speech, you characterized the minimum wage as an outright denial of economic liberty, and you stated that economic rights are as protected as any other rights in the Constitution. My question to you is, in 1987, did you believe that the minimum wage law violated economic rights which you thought were protected by the Constitution?
No, Senator. And I think I've made myself clear here, and I've discussed it here. I don't have a copy of the speech in front of me. The point that I was making with respect to minimum wage was a policy point, not a constitutional point. But let me address the constitutional point first. I have indicated that I believe that the court's post-Lochner decisions are the correct decisions, that those cases were appropriately decided, that the court is not a super legislature to second guess on the very complicated social and economic decision making of the legislative and executive branches. With respect to the minimum wage, there was an ongoing policy debate concerning what the impact of the minimum wage was on certain minorities, particularly minority teenagers. And there is data to suggest that each time the minimum wage rises, that minority teenagers, the unemployment rate increases. Now, that is not to suggest that the minimum wage itself is not beneficial. Indeed, it is. And I think we all would want everyone to make a decent wage. I certainly believe in that. But I think that there was a legitimate debate as to what are some of the impacts or unintended consequences of it, and that was the basis of that comment.
Well, Judge Thomas, as Chairman Biden pointed out on Wednesday, economic rights currently are not entitled to the same degree of protection as other rights, such as due process, equal protection, and free speech. If they did receive that degree of protection, it would be much harder for Congress to pass laws protecting the environment, workers' rights, and the safety of workers in the workplace. The speech in which you made that statement regarding economic rights was not a speech on political philosophy that you were giving to the Cato Institute, You were talking about the Constitution and economic rights. And you were talking to the business law section of the American Bar Association. These were corporate lawyers. I'm sure many of them were delighted to hear what you had to say about economic rights being protected by the Constitution as much as any other rights. But on Wednesday, in response to a question from Chairman Biden, you stated that in constitutional adjudication, it would not necessarily be the case that the protection of economic rights, quote, would be at the same level that we protect other rights. Now, based on what you said in '87 and what you told this committee, it would appear to me that today, as well as in your response to Chairman, that you've changed your views regarding this subject. You didn't make a distinction in your speech between young blacks and older blacks. We're talking about all blacks. What's prompted you to change your views on this matter of economic rights?
Senator, I've not changed my views. The point that I was making is that we do have rights, property rights, economic rights within our Constitution. Now, we have other rights in our Constitution. The question becomes in constitutional adjudication, at what level of scrutiny can those, or at what level of scrutiny does the court look at regulation of those rights? They do exist. They're in the Constitution. I don't think there's any disagreement about that. The level of scrutiny for socioeconomic, in this case that the relevant fact is economic rights, is rational basis. I have not quibbled with that, and I've made that clear. In fact, in that very same speech, or in one closely related to that, I made the point that the individuals who wanted to revisit the level of scrutiny for economic rights, I disagreed with them. Individuals, as Chairman Biden mentioned, such as Macedo. But the mere fact that you don't review those rights in the same way doesn't mean they don't exist, and it does not mean that they're not important. However, I think that we do recognize in this society is that there are some rights that we value that are so deeply embedded in our society, at the core of our society, such as our First Amendment rights, that we will review it with a different standard. But to review it as a different standard in no way says these rights are unimportant. It recognizes our political process.
Will the Senator yield my time when it comes around on this point? Because Professor Macedo has come up several times. I've raised him. And I'd like for the record to read a letter I received from Professor Macedo on Friday afternoon. I'm sure he wouldn't mind. And this is his book. He said I kept holding up Epstein's book. I might as well hold up his book. Enough. It says, Dear Senator Biden, many thanks for giving me 15 minutes of fame as Andy Warhol promised. Quite apart from this, though, it might be hard to profess objectivity now. Well, that's not relevant. He said, I could not agree more that natural law issue is worth pursuing and have been a bit disappointed by Judge Thomas's vagueness. I might note parenthetically, I've been very happy with that. As a token of my appreciation, I wanted to offer a few pieces of work to you and your staff. The article, The Right of Privacy, a Constitutional Moral Defense, is pretty clear and straightforward, I think, on the question of why something like natural law is inescapable in constitutional adjudication, as you have said at the hearings. I send along the book, etc. Then I want to read from just one paragraph of the article he sent along to make sure everything is clear in the record as to why both Senator Metzenbaum and I are pursuing this about Dr. Macedo. He says, quote, this is Steve Macedo's article, Economic Liberty and the Future of Constitutional Self-Government, sent to me Friday by Professor Macedo, and it is Macedo, M-A-C-E-D-O. The future economic liberty under the Constitution depends on the viability of the double standard, his words, the double standard that has for nearly half a century characterized judicial interpretations of our fundamental law. the modern court applied a searching level of scrutiny to challenge laws that interfere with a list of preferred freedoms, including liberties associated with speech, religion, and privacy, or that involve discrimination against discrete and insular minorities. At the same time, and despite the Constitution's several explicit supports for economic freedom, laws interfering with economic liberties and property rights are typically subjected to a lax test designed to establish only the merest rational basis exist for the law in question. In applying this double standard, as I shall explain at greater length below, the modern courts ignores the Constitution's support for economic liberty, disparages close connections between economic and other forms of freedom, and invests legislators with unwarranted measure of trust, trampling at the core ideal of our constitutional regime, the aspiration of reasonable self-government, end of quote. Now, the judge knew, and I knew, and everyone else knew why I asked that question. Because Professor Macedo believes that the standard, which I understand you have no quarrel with and accept, that's been around for a half a decade, as he points out, is one that we should continue. He believes it's one we should jettison. And that was the reason for the questions and the reason why I appreciate, whether I agree with it or not, I appreciate your answer, distinguishing the fact that you do not agree with Macedo that we should jettison this double standard, as he calls it. Am I correct?
That's right.
I thank the chair, and I ask unanimous consent that the letter to me be introduced in the record as if read. And I thank the chair for allowing me, or the chair.
You are the chair.
Well, I thank you very much. I'm not, sitting next to Senator Thurmond, I'm never sure what I am. He's always the chair, but thank you very much for the interruption, but I thought it was important to put that in the record, and anyone who wants to look at the book, this is it, Liberal Virtues.
One last question on this matter of the minimum wage, because you gave me a rather lengthy answer, but I think this just takes a simple yes or no. Do you still believe that the minimum wage law is an outright denial of economic liberty for employers?
Senator, I think that I characterize it in the way that I think is that I meant it, and that is that it does have unintended consequences of eliminating certain individuals or precluding them from entering the job market. There is data on that. I have felt...
To the question, Judge Thomas, I beg to point out to you, you're talking about the impact of it. I'm not asking about the impact. You're saying it does preclude certain individuals from obtaining jobs. My question is, do you still believe that the minimum wage law is an outright denial of economic liberty, which is what you had stated, I think it was in 1987?
And I explained, Senator, I think what I meant by that. It does not allow certain individuals to enter the workforce. And I did not intend to suggest, as I've also indicated to you, that this was some sort of constitutional judgment. If we're talking about constitutional law, liberty in that sense, then the answer is no. That is not what I'm saying.
One of the most puzzling parts of your testimony to the committee last week is your suggestion that we should discount most of your past statements on legal and policy issues because those were made in your role as a policymaker rather than as a judge. The interesting thing is that your supporters assert that your childhood experience of growing up poor in the segregated South is a very important part of our consideration, and I agree with that. Your supporters argue that your personal history demonstrates that you will bring sensitivity to the bench when considering issues of race and poverty. I'm not sure whether I agree with that. You have basically said the same thing to us. In other words, your argument seems to be that your childhood background is more relevant to assessing your qualifications for the High Court than are a decade of speeches and writings and an 8-year record while head of the EEOC. Frankly, Judge Thomas, I have difficulty with that. Your tenure at EEOC is the major portion of your record. That is what qualified you for the Court of Appeals. And quite frankly, your tenure on the appellate court has been so brief that it gives us little indication of what kind of justice you would be on the High Court. By your own admission, you spoke out on a number of issues during your chairmanship at the EEOC. Judge, I start from the assumption that public officials mean what they say. I do not think you are going around the country articulating views and advocating policy positions that you did not believe in. And if you were articulating views or advocating positions that you did not believe in, I think it's incumbent upon you to tell this committee when and why you were doing that. I have to assume that when you express views on legal and policy issues as EEOC chairman, those were your views. I can accept the idea that your views on certain matters may have changed between now and the time on which you expressed yourself on a particular issue. But it's difficult to accept the notion that the moment you put on that judge's role, all the views and positions which you held prior to going on the bench just magically disappear. That's not my experience, the way it is in the real world. If that was the case, then there would be no point in looking at anything beyond the past 16 months of your life. The pre-judicial record and positions of a nominee are usually a good indicator of what kind of judge that nominee will be. That's why we have these hearings, to explore that record and those positions. You have spoken out a great deal on contemporary social and political issues. I want to ask you about some statements you've made on these issues, because so often today's political or social issue becomes tomorrow's legal issue for the court. So I think it's important for the Senate to have a sense of how you think about these matters. I have copies of the speeches I want to ask you about. If you need to refer to those speeches or believe that a quote has been taken out of context, you should say so. I'm trying to get a sense of how you think about political and social issues, and it's important that we be accurate. For example, in an April 1987 speech, the Cato Institute, which has been referred to quite often, you stated that you, quote, agree wholeheartedly with former Treasury Secretary William Simon's statement that, quote, we are careening with frightening speed toward collectivism and away from free individual sovereignty, toward coercive centralized planning and away from free individual choices, toward a statist dictatorial system and away from a nation in which individual liberty is sacred. Now, Judge, this statement, frankly, does not comport with the reality of American political life in 1987. Why is it that in the 7th year of one of the most conservative administrations in this century, you believe that this country was, quote, careening with frightening speed toward a statist dictatorial system?
Senator, I think that I have not had an opportunity to go back and review that speech in detail. I've looked at it and don't know exactly where that quote appears in it. But the point that I think throughout these speeches is a notion that we should be careful about the relationship between the government and the individual, and should be careful that the government itself does not at some point displace or infringe on the rights of the individual. That is a concern, as I've noted here, that runs throughout my speeches. In quoting former Secretary of the Treasury Simon, I think I was just underscoring that point.
Well, Judge Thomas, if you have the speech in front of you, or if you don't, I'll send it to you. Let me point out to you that where it appears, because I think that is very significant, and I think you've made a significant point. It's in your windup. I find myself agreeing wholeheartedly with former Treasury Secretary William F. Simon when he asserts that, and then I read the whole quote, and then you go on to say, I can't think of a more appropriate time for truth than the bicentennial of our Constitution. Thank you. Now, was there some material in between? I'm informed by my staff that was the very end of the speech.
Which speech was that now, Senator?
This was the speech to the Cato Institute on April 23rd, 1987. And my question to you is, so we don't lose sight of it, is that this was the 7th year of the Reagan administration. And I'm trying to find out from you how you concluded that the country at that time was careening with frightening speed toward a statist dictatorial system.
Senator, as I indicated to you, and I think as I indicated throughout this speech, that the point that I was making is that we were losing sight of it was my feeling that we were losing sight of the relationship, the appropriate relationship between the individual and the government. And in quoting former Treasury Secretary Simon's speech, I think it was simply to underscore that point.
And you thought this was happening during the Reagan administration?
I think the relationship, my point was, again, as I indicated, that the concern seemed to be diminished about the rights of the individual, and I was underscoring that point with that quote.
I'll go on. In an April 1988 speech at Cal State University, you declared that, quote, that those who have been excluded from the American dream increasingly are being used by demagogues who hope to harness the anger of the so-called underclass for the purpose of advancing a political agenda that resembles the crude totalitarianism of contemporary socialist states much more than it does the democratic constitutionalism of the Founding Fathers. Oh, Judge Thomas, I think most Americans believe that any laws that resemble the crude totalitarianism of contemporary socialist states, your quote, would be inconsistent with our Constitution. I think most Americans believe that if you were confirmed, you would have a duty to strike down any such laws. That is why we need to know what you meant when you used such terms. In 1988, when you made that statement, what programs and policies did you have in mind when you spoke of a political agenda that resembles the crude totalitarianism of contemporary socialist states?
The point that I was making in that particular portion of the speech, again, was this, that there seemed to be some efforts to disenchant or to encourage or to take advantage of disenchantment of certain individuals in order to, I think, and this was again a policy point of view, to enlarge in the role of government. That was a concern of mine. I think it's consistent with the concern that I expressed to you or that I expressed in the Cato speech. I think that that was an appropriate concern. Of course, once again, there's quite a bit of rhetoric there, but the point is quite simply that the relationship that I felt was getting lost in the shuffle and in the confusion was the relationship of the individual to the government.
That speech was in 1988, and in your speeches in 87, 88, you seem to be talking about running towards this totalitarianism, towards a socialist state. And yet it's in a very conservative president's administration. And I sort of wonder, were you just using words to make a good speech? Or did you really believe the things you were saying because the facts belie your assertions?
I think, Senator, I also made it a point to bring the same concerns with respect to particularly minority individuals whom I've noted in this speech on in its relationship even with the administration, that the administration was not addressing those concerns, and certainly were not at that time addressing minorities as individuals. I think that that was one of the reasons and one of the bases of the Heritage speech.
Yes, but the concern for the minorities was not being expressed by that administration. It was the reverse, and it wasn't that totalitarian socialist state about which you speak. That wasn't the problem. The problem was to try to prevail upon a conservative Republican administration to be concerned about minorities' problems. It wasn't this other concern about which you speak that was affecting minorities, as I see it. Let me go on. You wrote a chapter of a 1988 book entitled Assessing the Reagan Years, in which you dismissed as an invention the argument that the Ninth Amendment undergirds the right to privacy. In the article, you expressed concern that the Ninth Amendment provides judges with a blank check to strike down legislation deemed by the court to violate certain unenumerated rights. You also state that the Ninth Amendment will likely become an additional weapon for the enemies of freedom. End of quote. In 1988, Judge Thomas, who are these enemies of freedom that you were referring to?
Senator, the point again that I was making, I've noted what my approach and concern about the Ninth Amendment itself was. It was the concern that judges would use the Ninth Amendment without reference to anything more than his or her own predilections, and that the adjudication of the Ninth Amendment had to be rooted in something other than that. It had to be rooted in tradition and history. With respect to my concern, the larger concern, it was that these efforts would be to enlarge the government at the expense of the individual, not so much on a commentary on the Ninth Amendment, but it's the overall point that I've made throughout these speeches, the relationship of the government to the individual.
Well, but you didn't answer who were these enemies of freedom.
Well, I don't think I named any. I think it was just a general, those who...
Anybody in mind?
Not in particular, Senator.
In an October 1987 speech, the Cato Institute, you expressed concern that maximization of rights is perfectly compatible with total government and regulation. Unbound by notions of obligation and justice, the desire to protect rights simply plays into the hands of those who advocate a total state. End of quote. It sounds like you had serious misgivings about protecting rights. In 1987, how did you think the protection of rights could lead to a total state?
Senator, I think the point that I've made earlier in the hearings is that I wasn't talking about the rights that we consider fundamental, but that one could just simply say that he or she has a particular program, and that program then becomes a right, and that it would actually be nothing more than one's preferences, as opposed to the rights that are protected in the Constitution, and that a proliferation of these rights or policies would actually undermine the value of the rights that we hold near and dear, or the rights that are currently protected by our Constitution.
Well, but in a 1988 speech, the Pacific Research Institute, you said, too great an emphasis on rights can be harmful for democracy. I needn't tell you that if you're confirmed, your job in the Supreme Court will be to protect the rights of Americans. What led you to believe that emphasizing rights can harm democracy?
Senator, as I indicated, the rights that I was talking about there was not our constitutional rights, but rights that could proliferate simply by name, and these rights are nothing more than programs or policies as opposed to our constitutional rights or our fundamental rights.
Let me go to a different subject. During the past 15 years, a number of American companies adopted policies which barred women from certain jobs unless they could prove that they were not capable of bearing children. These so-called fetal protection policies left working women in the unconscionable position of having to undergo irreversible sterilization if they wanted to keep their jobs. Tragically, that's just what happened to a number of women at companies such as American Cyanamid and Johnson Controls. 6 months ago, the Supreme Court completely banned these policies as illegal sex discrimination. Judge Thomas, as head of the EEOC, from 1982 to 1990, you had responsibility for protecting the millions of working women in this country against sex discrimination. Shortly before you took over, the EEOC decided not to resolve allegations of sex discrimination involving these fetal protection policies until it developed a formal position on the issue. In the interim, the sex discrimination charges were investigated in the field and then simply sent to the Commission's headquarters in Washington, where they were held pending the development of an EEOC position. But under your leadership, under your command, the EEOC failed to address this intolerable situation, not for 1 week, not for 1 month, not for 1 year, but for over 6 years. During this entire period, dozens of charges of women involving fetal protection policies sat at your headquarters without resolution. The women who filed those charges had rights, but their rights became meaningless in the absence of enforcement. And they didn't just lose their rights, Judge Thomas. These working women lost their jobs, their careers, their dignity, and in some cases, even their ability to bear children. Under increasing pressure from a House Education and Labor Committee investigation, the EEOC finally took a position in 1982 and began to resolve these charges in 1988 they took the position, and began to resolve these charges in 1989. By that point, over 100 charges had piled up. Your agency couldn't even find many of the women who had filed the charges, so their cases were thrown out. For these women, justice delayed was justice denied. I am very troubled by the EEOC's complete abdication of its entire enforcement responsibilities in this area. I am particularly disturbed because it appears that you were personally involved in the Commission's decision not to protect women from these policies. First, a memorandum prepared by the EEOC's Office of Legal Counsel described your personal preference that the EEOC refrain from deciding whether these fetal protection policies could be illegal under any circumstances. Quote, on Chairman Thomas's suggestion, the EEOC staff manual now emphasizes that the Commission has not decided whether an exclusionary policy or practice is or can lead to a violation of Title VII, end of quote. Second, in a memorandum written to you in 1983, one of your own staff aides emphasized the need for the EEOC to decide whether these policies were illegal. Since the charges once investigated will have to, this is the quote in the memo, since the charges once investigated will have to be dealt with in some fashion, I recommend that the staff begin now preparing options for handling them. Otherwise, the Commission could end up with an inventory of unresolved and unresolvable charges. That was in 1983. You responded by writing at the top of the memorandum, let's discuss. I have serious problems with this area, end of quote. You must indeed have had serious problems because you ignored that staffer's warning and left women unprotected for a total of 6 years. Judge Thomas, why did it take you 6 years to help the women, or to take any action to help the women who had filed these charges?
Senator, as you've noted, this was a very difficult area. the question for us was, if an employer has a policy that says that women will not be allowed in a certain job because the job itself, the radiation, or I believe in Johnson control, battery acid, could lead to harm to the ovaries or to the woman's ability to bear a healthy child, or the next generation could have problems such as cancer, etc. Initially, the concern was, how do we make a judgment as to these health risks? I think we had extensive coordination, or worked with OSHA. I believe we worked with the EPA, et cetera, to try to make this determination. What standard, what standard do we apply, and what role do we play? Again, I'm basing this on my recollection of the early 80s. We subsequently decided to, our normal procedure in that instance is to bring the cases into headquarters until we develop a policy. This was one of the more difficult areas as we were developing other policies. This wasn't the only policy. Ultimately, I think we moved to giving guidance that indicated that the decision would have to be made based on business necessity, which was a strict standard. And finally, the position which we adopted was that if an employer were going to exclude women, it had to be based upon a bona fide occupational qualification. And that's ultimately the standard that the Supreme Court adopted.
Mr. Chairman, I have about 10 or 15 minutes more on this one subject, and then I would be concluded. I'm perfectly willing to wait my turn and come back for the next round, and I just want to know the Chairman's whether he desires me to conclude.
Well, I would think that we should take a break now in any event, to give the judge an opportunity to stretch his legs, and we can just huddle here for a second. I might say right now, Judge, I'm trying to figure out the time, because we are going to finish with you today and early, even if, as I said on Friday, even if we have to declare 2 o'clock the lunch hour. But it looks as though we have somewhere between 20 and a half an hour more on the Republican side, maybe. I'm not positive of that. I think that's right. Senator Hatch has a few questions, and I don't know whether anybody else has any more questions. And on the Democratic side, my questions, depending on how quickly we go through them, could take anywhere from 20 to 45 minutes. I don't know. It depends on the discussion we get in, if we do get in. It's mainly recapitulation. I can tell you now, I'm going to talk to you a little bit about expressive conduct in speech and separation of powers. Senator Kennedy has around 20 to 30 minutes. The senator from Ohio has 15 minutes or so. The senator from Vermont has...
Chairman, I think I would take my full time. I understand Senator Thurman stated that the witness misunderstood my question when I asked about cases during the past 20 years. I may want to go back into that but now the question's fully understood what I meant by the 20 years, and I'm glad to go into that, but I also have some other areas, so I would expect to take my full time.
All right, and the senator from Alabama has roughly one round, is that half an hour, is that correct? And the senator from Illinois is about 10 minutes.
Less than half an hour.
Less than that. So we're down to the wire. Now, what I'd do is ask you, as we break these 10 minutes, to make a judgment as to how we're going to do that. But let's...
Mr. Chairman, in view of Senator Metzenbaum's question, Senator Hatch desires some time to answer him.
Okay, well, look, let's not get upset about it. We're close, and let's just keep plugging along. Let's take a 10-minute break now, Judge, and then maybe Mr. Duberstein and I can speak a minute here, okay?
They're not
Senator Orrin Hatch,
halfway. I think
Boston
they're
on
just about halfway done.
Been doing...
Poor Clarence has no idea what's coming at this point, I don't think. I don't think he knows that the Anita Hill of it all is going to be coming, which it's normal to have witnesses come up and say something about you in the second half of your hearing, so they had the same thing. But circus that this hearing devolved into. In the first half of today, we got through some Chevron, his opinion on the Korean War. He talked about minimum wage, Lopez, which is the commerce clause.
Before I yield to Senator Hatch, what we've been doing, I say to the public in the interim, is trying to figure out how we best order bringing the testimony of Judge Thomas to an end without cutting off what are legitimate questions that are left, and there are some. I think if we just let the string run here, we're going to do just fine. Except, and I received an admonition, though, Judge, I want to tell you this. Your mom may be angry I'm saying this. She said she wants to go home. And she told me she has one of her patients who's 104 years old, who's been watching this on television, saying, when is she coming home? And she told her patient, Clarence won't let me. And I'm sure you're going to tell her Biden won't let Clarence.
That's right.
So, but let's see if we can move this along now, okay? And again, I don't mean in any way to disparage. There's some very important questions that are left, but I think we can, if we just move with dispatch here, whether or not we get it done by a lunch, we'll get it done. We're not going to be long beyond that. I think we still maybe be able to do that, but let's just move along. Senator Hatch.
Thank you, Chairman Biden. I don't want you to go home either just yet. I think you've really added a lot to these proceedings, so we're proud to have you here. Judge, I think you fully understand that it's awful tough when you make a lot of speeches in the past, and I'm sure that some of those speeches were written by ardent and well-intentioned staff, as they are for us in many cases, and I think we all understand that. But you're being criticized on one side for not being liberal enough, and then I notice in the press this morning there are other articles that are criticizing you for not being conservative enough. So I think it just goes to show that you can't please everybody. But I do just want to take a few minutes because Senator Metzenbaum did go into your EEOC record. And I think the Washington Post sums it up pretty well, because on May 17th, 1987, the Washington Post said this, and you'd been in there for, what, 5 years at that time? Okay. Here's what the Washington Post said. Quote, things are markedly different at the Equal Employment Opportunity Commission. Here, the caseload is expanding and budget requests are increasing. Under the quiet but persistent leadership of Chairman Clarence Thomas, unquote. Now, that's pretty darn good after 5 years, being in this very tough maelstrom of a position, to have the Washington Post praise your leadership, knowing that you were in the Reagan administration, which they didn't very often praise, and some people think with just cause. But I think it's important to point that out. Secondly, let me point out some more. When you became chairman of the EEOC, I was chairman of the Labor Committee at that time. Senator Kennedy was my ranking member. Now it's reversed. He's chairman, I'm ranking. But we overviewed the EEOC. And when you became chairman of the EEOC, the General Accounting Office, right at that time, issued a report on the state of the EEOC. And that report listed the numerous financial and managerial problems at the Commission. In fact, it was entitled Continuing Financial Management Problems at the Equal Employment Opportunity Commission. It was issued May 17, 1982, right at the time you came into office. Now, if you just look at some of the, well, first of all, the 1982 GAO report talking about the predecessors who had operated the EEOC. They found that the agency up to that time couldn't even control its funds or its accounting practices. They said, quote, the Commission has failed to properly maintain and operate the system. Records and reports produced were unreliable. Receivables were not properly collected, and bills were not paid on time. Also, in failing to follow some established procedures, the Commission's employees have created violations of law that now must be dealt with. These problems predated you coming into the Commission. In the 1981 interim report, GAO stated that, quote, some of EEOC's actions, now this is even before you were put in, quote, some of EEOC's actions may be thwarting its efforts to eliminate employment discrimination, unquote. Then the Office of Personnel Management released another report on the EEOC in May 1982. It was entitled A Report on Personnel and Administrative Management in the Equal Employment Opportunity Commission. They had audited some 60 jobs at the EEOC's Office of Administration before you became chairman or went to that commission. They audited these 60 jobs to determine the relative accuracy of the EEOC's pay scale, and they found that 53 positions were overgraded. 42% of the positions were overgraded by 3 or more grades. 26% were over 2 grades, and 32% were by 1 grade. Just look at the headings of the summary of findings. I think they indicate the disarray the EEOC was in when you came. Number 1, substantial overgrading exists within the Office of Administration and likely exists in other parts of the agency. This is before you came in. This is the predecessor agency. Number 2, the supervisory structure is excessive and expensive. Number 3, the personnel office's 2 core programs, staffing and classification, are not in compliance with OPM requirements. Number 4, administrative operations are deficient in closing out contracts, accounting for physical property, cataloging in the library, and mailroom operations. Number 5, the agency's management accountability plan may be failing to account for quality of its achievements. Number 6, management appears to have tolerated and contributed to a work environment beset by acrimony, improper employee conduct, poor performance, and favoritism. All of those are the titles, the headings of the sections in that OPM or Office of Personnel Management report. I mean, let me ask you a question. Did you work on those problems?
Senator, during my confirmation hearings in 1982, one bit of advice that you gave me, indeed, you told me you would hold me accountable for within a short period, was to correct particularly the financial problems within a short period of time. And we were able to do that. In fact, we were able to correct the financial accounting problems and have a GAO certified system, I believe, within 2 years. You asked.
EEOC had $1 million they couldn't even account for, isn't that so? At that time?
That was one of the items that you told me specifically to account for in the travel area.
You cleared that up and resolved it?
We cleared that up and put in place a variety of procedures and a variety of checkpoints so that that would not reoccur. And I think it would not be overstating the case to say that EEOC today has one of the finest financial accounting systems in government.
Is it not true that each one of those problems listed in that OPM report and listed in the GAO report you either improved or resolved?
We resolved those, I believe, shortly after you instructed us to do so. As chairman of the Labor and Human Resources Committee, we attempted to address some of the long-term problems, but the recommendations that were made in the GAO report became the basis for our short-term plan, the immediate actions that we had to take upon arriving at EEOC. But most of those problems were corrected, I believe, within the first year or 2.
In fact, you cleared up monitoring consent decrees and settlements. You ensured not only that the judgments were won, but that they were enforced. I think most who know you would say, and watched your tenure, would say that you were creative when changed circumstances necessitated an alteration in ongoing consent decrees. Some would cite the Ford Motor Company situation as one of the highlights. You certainly aggressively corrected and improved management of the systemic litigation system, which was in disarray at the time. I could go into all of that. I don't want to take the time. I just want to make the point that some of these criticisms that are being brought up about the EEOC are not only wrong and misinformed, they're distorting what really happened, because you inherited an agency that was in disarray. The people were fighting with each other. They weren't bringing the litigation as they could. Even the age discrimination cases were in disarray. You didn't have a central management system that was working well. You didn't have a good accounting system or a good financial system. You had a lot of backbiting among employees. because they were upset with each other, because there wasn't the management team that was necessary, and all of that, as far as I can see, during your tenure, was improved upon or resolved. Is that a fair statement?
We did our best, Senator, and we think that we not only addressed those problems, but we were able to do some, or engage in some practices and to engage in some programs, develop programs that took EEOC far beyond where it was in 1982.
Well, I have to say that I think most who really know the situation, and I happen to know it, can find something to criticize no matter what, because it's a big agency with a lot of problems, and they're tough problems. They're among the toughest problems in our society today. They involved equal employment opportunities and all kinds of other civil rights areas. It's a very complex area. So they can find faults, but the fact is that you cleared up all of these tremendously difficult problems that existed down there. Some would say that you really, in fact, most would say who know, in fact, I think all would say who know that you had you put forth an aggressive effort to stamp out workplace discrimination at the time that you ran the EEOC. In fact, some would say that's unquestioned. Litigation recommendations received from district offices increased dramatically. The changes went up as high as 400% or 500%. Increase in better approaches at the EEOC. I don't want to take the time of the committee because I know we're trying to get through this and do our very best to finish today, and I don't want to take anybody's time. But let me just go into this one problem on fetal and reproductive hazards that Senator Metzenbaum brought up. And if I understood his charge, it was basically that at the EEOC, at the time you were chairman, women who were barred from certain jobs because of fetal protection concerns did not have their rights enforced. But let me just respond to that. During your tenure there at the EEOC, there was and you correct me if I say anything wrong here, there was a legitimate difference of opinion among lawyers and others over whether Title VII forbids employers from excluding women from jobs that might endanger any unborn children that they might be carrying or that they might carry in the future. Now that's a very, very complicated area of employment law and Title VII law. It involves scientific and medical considerations as well as legal considerations. And because of the complexity of the issue and because other government agencies such as OSHA, the Occupational Safety and Health Administration, and the EPA, the Environmental Protection Agency, had to weigh it in their views or weigh in with their views on this issue, it naturally took some time for the EEOC to formulate a position on this issue. And as it did, fetal protection discrimination charges that were filed with the EEOC were naturally held in abeyance because a judgment had to be reached, a fair judgment taking into consideration all of the matters, including medical and legal and other matters. But because the charges were filed that were held in abeyance, they were not prejudiced because they actually had been filed. Is that correct?
That's right.
So you had protected the rights of these people during the time that the medical, legal, scientific, and other considerations were taking place. And the filing of the charges told the statute of limitations and stopped it from running. Moreover, the plaintiffs whose charges were held in abeyance, they were free, as I understood it, and correct me if I'm wrong, they were free to sue privately in federal court. Is that correct?
They could have perhaps received the right to sue letter and gone on into federal court, Senator.
If they had wanted to.
That's right.
So nothing was interfering with their rights to do that, which was a very important right.
That's right. The difficulty, Senator, as you've pointed out, was that it was a very complex area and a very an area that involved a tremendous amount of work safety related problems as well as health and medical problems and concerns. And we attempted to work them out, but EEOC, or to wrestle with them, but EEOC does not have the scientific and medical capability to, on its own, or did not have the capability to make all of those determinations. We attempted to coordinate, as I said to Senator Metzenbaum, with the other agencies. That took some time. However, even during that process, we gave significant detailed guidance, I believe in 83 or 84, to the field on how to handle and how to investigate these charges, and then ultimately to forward those to our headquarters.
All right. After study of the issue in 1988, the EEOC, as I understand it, issued regulations reflecting case law as it had developed up to that time in the federal courts of appeals. Now, the regulations permitted fetal protection restrictions on female employees only when the employer demonstrated that there was a substantial risk of harm to the fetus and that there were no other reasonably available, less discriminatory alternatives that would effectively protect female employees' offspring. Is that correct?
It sounds accurate, sir.
Okay. Further, the EEOC regulations required that if there was a similar danger to male offspring, that fertile men be excluded from the positions as well. So you handled it that way. And when I say you, I mean the EEOC, because you don't just do these things by yourself. After the Seventh Circuit ruled in 1989 that plaintiffs had to bear the burden of disproving that an employer's sex-based fetal protection policy is justified by business necessity, the EEOC announced that it rejected that decision and that its regulations, the burden of proof remained on the employer to show that a fetal protection exclusion was a bona fide occupational qualification under the criteria of the 1988 regulations. This year, the Supreme Court in International Union v. Johnson Controls, Inc. agreed with the EEOC that the burden of proof is not on plaintiffs in fetal protection exclusion cases. So they came down to the same point of law that you had come up with. But in addition, however, the court went further and held that a fetal protection exclusion policy can never be justified as a bona fide occupational qualification. But the bottom line is that no one was prejudiced by the EEOC's consideration of this extremely complex set of cases, or issues, should I say, and that the position taken by the EEOC was reasonable in light of the fact that it was based on the developing case law in the courts of appeals. Now, I just wanted to bring that out because I think that if that isn't brought out, you're not being treated very fairly, because you did everything you knew how to do under the circumstances, and finally the Supreme Court resolved it. And it resolved it going a little farther than the EEOC went, but nevertheless adopting basically your ideas up to that point. Now, one last thing. When the Justice Department was considering amicus participation in the Meritor Savings Bank versus Vinson case concerning whether sexual harassment on the job constituted a Title VII violation, would you be kind enough to tell us what role you played in formulating the government's position?
Senator, that case, of course, involved the instance in whether or not there could be sexual harassment outside of the context in which a woman does not receive a promotion, or as a result of not agreeing to engage in the prohibited conduct. That is, a woman does not concede to the wishes of the supervisor. It was whether or not there could be a hostile working environment. Our agency, as was the practice, communicated with the Justice Department that we felt that the government should be actively involved in this case. There was some resistance. Some individuals argued that hostile environment was not a violation of Title VII as sexual harassment. My direct role was not only at EEOC in developing the arguments that were transmitted to the Justice Department, but to personally meet with the solicitor, his staff, individuals who disagreed throughout the Justice Department, and to argue for the government's involvement in that case in the Supreme Court. and ultimately EEOC itself played a very extensive role in the development of the legal arguments in that case in the Supreme Court.
Well, that's great, because that issue of whether sexual harassment on the job constituted a Title VII violation, then Solicitor General Charles Freed of the Harvard Law School, he said that was an open question the court had not resolved. So he then sought the views of the EEOC. He came to you and said, we'd like to have your ideas on this tough question. We'd like to know where you stand. And he personally said that you, Judge Thomas, then Chairman Thomas, chairman of the EEOC, forcefully argued that the federal government should side with the woman plaintiff, that sexual harassment is clearly discriminatory and cognizable under Title VII. This issue that was not decided, had never been decided by the court. As you know, the government did side with the woman plaintiff in the Meritor Bank Vincent case, and the court finally held that sexual harassment, creating an offensive, hostile, or abusive work environment, constitutes sex discrimination under Title VII. I think it needs to be pointed out for a number of reasons, but the principal reason is, so when the chips were down, when that case could have gone either way, as either not within the confines of Title VII, in other words, outside of Title VII and therefore not enforceable, or within, Chairman Thomas argued forcefully with the Solicitor General's office and with the administration that sexual harassment of women should be included within Title VII, and the Supreme Court upheld your position. Now, I just wanted to bring that out. Now, I think it's also important just to conclude with this comment. These are very difficult areas of law. Reasonable people can disagree, and without any prejudice on the part of anyone. And I contend that Chairman Thomas, once you get on that court, you're going to be watching out for the people, the little people out there that many are worried about, who need help and who need their rights resolved and watched over. And you'll do it in a fair and reasonable, responsive way, as you did at the EEOC. And I have to say, the EEOC still has plenty of room for improvement, as does every agency of government. But compared to what it was in 1982 when you took over, it's worlds apart. And you're the person who helped bring about the effective and good changes. And that needs to be said by somebody like me who has watched it for all these years and takes a special interest in it, and who wants that agency to work right and well. So I just wanted to say that and correct the record and commend you for the service you've given, and I have absolutely no doubt that you'll give equal service, if not better service, on the Supreme Court in the interest of everybody in America. Thank you, Mr. Chairman. I think I've taken about 15 minutes. I didn't intend to take more than 10, but I apologize.
Thank you very much, Senator. Senator from Massachusetts, Senator Kennedy.
Thank you very much, Mr. Chairman, and I wanted just to return very briefly to a couple of areas that we talked about last Friday, Judge Thomas. Welcome back. Judge Thomas, I want to come back briefly to the subject that we talked about on Friday, which your view on Justice Oliver Wendell Holmes. On Friday, when I asked you for your view about Justice Holmes, you said that, and I quote, "He was a great judge. Of course, when you have opportunities to study him, we might disagree here and there, but I had occasion to read a recent biography of him, and obviously now he's a giant in our judicial system." I then read your quotation from a speech you gave at the Pacific Research Institute in 1988, including a portion in which you quote a statement by Walter Burns on Holmes. And you correctly stated that I was quoting your reference to Walter Burns' view of Holmes. But I just want to read the entire passage into the record so that your view of Justice Holmes in 1988 is not misunderstood. You stated, and I quote, "We cannot expect our views of civil rights to triumph by conceding the moral high ground to those who confuse rights with willfulness. The homage to natural right inscribed on the Justice Department building should be treated with more reverence than many busts and paintings of Justice Oliver Wendell Holmes in the Department of Justice. You will recall Holmes as one who scoffed at natural law, that brooding omnipresence in the sky, If anything unites the jurisprudence of the left and the right today, it is the nihilism of Holmes. As Walter Burns puts it in his essay on Holmes, most recently reprinted in William Buckley and Charles Kessler's Keeping the Tablets, and here you quoted Mr. Burns, "No man who ever sat on the Supreme Court was less inclined and so poorly equipped to be a statesman or to teach what a people needs in order to govern itself," end of quote of Burns. And then you continued, or as constitutional scholar Robert Faulkner put it, and here you quoted Mr. Faulkner, "What John Marshall had raised, Holmes had sought to destroy." That's the end of quote of Faulkner. And you continued, "And what Holmes sought to destroy was the notion that justice, natural rights, and natural law were objective, and that they exist at all apart from willfulness, whether of individuals or officials." So I think it's quite clear from the full quotation that Judge Thomas, that you were harshly critical of Justice Holmes for what you described as his nihilism and his effort to destroy your view of natural law. And it doesn't sound to me like you thought he was a great judge in 1988.
I guess, Senator, much of that perhaps resulted from the concern about some statements in cases like Buck v. Bell of Justice Holmes.
Well, which is Judge Thomas's opinion, the one of Justice Holmes, the one you gave on last Friday or the one you gave in 88?
Well, I have, as I indicated, Senator, I have concerns about statements like 3 generations of imbeciles is enough or sufficient. I think that we certainly would find problems with that. What I indicated to you was that I did take the time to go back and reread about him. I mean, even though I may have had disagreements, that was not the end of the inquiry. I spent a considerable amount of time going back and trying to understand him more during my tenure on the bench.
Well, that was then, and last Friday is now?
No, last Friday, as I indicated, I had gone back recently and read a biography of him subsequent to the speech. That was the point.
Well, as I understand, we'll leave it at this. Your view last Friday is your current view, and your statements that you said in 88 was your view of Justice Holmes in 88.
Well, he had my point that I was making, notwithstanding criticisms on the point that I made last Friday, is that he was a great justice, and whether we agree or whether I agree with him or not, or whether others agree or disagree with him. And the point that I'm making now is that even though I might have had a point of view in 1988 that was critical, that did not stop me from going back and reading and learning more about him. I think that the important point that I'm trying to make is merely having a point of view is not the end of the process for me. It is indeed the beginning of the process of learning and growing and attempting to change if there's evidence there.
Let me go on to the voting rights. We talked briefly about it last Friday. You made some comments earlier in the course of the hearing this morning. In 88, you stated, unfortunately, many of the court's decisions in the area of voting rights have presupposed that blacks, whites, Hispanics, and other ethnic groups will inevitably vote in blocks. Instead of looking at the right to vote as an individual right, the court has regarded the right as protected when the individual's racial or ethnic group has sufficient clout. In reviewing the Supreme Court decisions, the principal decisions decided on the voting rights case, the White v. Register and the Thornburg case, there's an Allen case as well, but that deals with pre-clearance provisions. But on basically that very issue, these, as I understand it, are the principal cases, and both on their very face rejected the block voting. Even in White v. Register, we have entertained claims that multi-member districts are being used invidiously to cancel out or minimizing the voting strength of racial groups. To sustain such claims, it's not enough that the racial group allegedly discriminated against has not had legislative seats in proportion to its voting. The plaintiff's burden is to produce evidence to support findings that the political process leading to nomination and elections were not equally open to participation by the group in question, that its members had less opportunity than did other residents in the district to participate in the political process and elect legislators of their choice. We're talking here about how state legislatures in Texas and North Carolina had at-large elections, allegedly, and I think supported by the evidence considered in both of these cases decided by the Supreme Court, that the at-large elections, rather than the single-member districts elections, were being used to diminish and undermine the effectiveness of the rights to vote of individuals, the blacks in Dallas, Hispanics in San Antonio, blacks in the Thornburg case. Similar statements in the Thornburg case, I think even stronger. Those and the Allen cases were the three, as I understand it, the major guiding beacons in terms of the Supreme Court's upholding the importance of the right to vote, certainly in judging the actions of the legislatures, which in many instances, particularly in the Texas legislature, had a history of supporting segregation activities at that time. And we have seen subsequent to those decisions, the changes in the membership in those particular districts rather dramatically, I might mention. Well, what were you so critical of in terms of those cases? Were the principal cases?
Well, the comment wasn't about the Thornburg case, Senator. The concern that I raised, I think the word I used was presupposed block voting. And that had to do with, and as I noted, I think on Friday, that I was not engaging in an exegesis of the voting rights cases. The comments were made in a speech that was about individual rights and the concern for individual rights and what would happen to individuals versus when you consider groups versus individuals. And I simply used as an example and referred to, I think in one paragraph, maybe two, the Voting Rights Act as one of the examples, and then I moved on. The point that I was trying to make was that, and it was there was a school of thought, there was thinking I remember being involved or reading about the debates in the early 80s about the Voting Rights Act that felt that the early cases presupposed or would lead to proportional representation. It was that kind of mentality that I felt presupposed that blacks would vote a particular way, that there was just stereotypes. And throughout all my speeches, I argued against the use of stereotypes. I think there was even some debate up to and immediately prior to the amendments to the Voting Rights Act in '82 concerning proportional representation. But I was not, as I indicated, going through any cases and specifically saying, here is the precise language in that case, but rather to that general school of thought that interpreted those cases to require proportional representation. I think that was also a concern, as I remember, and again, I was not directly involved in the debates over the Voting Rights Act, but I think that there was some concern even then with the legislation that came from the House of Representatives, that it might lead to, the results test might lead to proportional representation. The language, of course, in the Voting Rights Act, in the amendments, preclude that. And of course, the Thornburg case makes it clear that you don't presuppose now that there's block voting, but rather it has to be proven. So what I was talking about was this general assumption about, had to do with the school of thought with respect to proportional representation and the presupposition that minorities all voted the same way or thought the same way or acted the same way.
Well, I'm interested in your view of the legislative history because Senator Mathias and I were the principal sponsors of the extension of the Voting Rights Act and very much involved in the debate, and the legislation specifically includes in the Title II, explicitly says that no group is entitled to legislative seats in numbers equal to their proportion in their population. So at least among those that were very much involved in the legislative history as well as the Supreme Court. So the only point I raise is when you mention here many of the court's decisions, I was just trying in my own mind and recognizing the importance of voting rights to find in my own mind what were the areas of the Supreme Court decisions in voting rights that you're most critical of. But as I understand now, and I'd like to move on, that with regards to the White and Thornburg, that you support certainly their outcomes.
I absolutely support the aggressive enforcement of voting rights laws, and certainly support the results in those cases. I think I said that or attempted to say that last Friday.
Let me move on to another area that was touched on during the course of the hearings, but which I'd like to just clarify. This was, Judge Thomas, in your exchange with Senator DeConcini yesterday, you talked about your role in Adams v. Bell. The Secretary of Education, Terrell Bell, was the defendant in that lawsuit, and back in 1977, the court had ordered the Office of Civil Rights in the department to process discrimination complaints more properly and conduct compliance reviews within specific time frames, and you arrived as the head of the Office of Civil Rights in May of '81. So we have the court going back to '77, you arrive in '81, you were the official responsible for compliances with the court order. Your agency was accused of ignoring the court order timeframes to act on race discrimination complaints, sex discrimination complaints, and other discrimination complaints in a timely manner. And the plaintiffs in the case petitioned the court to hold you in contempt for violating the court order, and the court held a hearing on the petition on March '82, which is 9 months after you'd taken office. And you told Senator DeConcini the judge did not hold you in contempt or take any other steps. You said, and I quote, "I think ultimately what the judge realized is that we were doing all that we could, that it was impossible for us to comply with it," meaning the order, which is the end of quote. Well, that, as I understand, is not quite right. I'd like to quote from the contempt hearing on March 15th, '82. The judge concluded that instead of enforcing the civil rights law, you were dragging your heels, carrying them out in your own way and according to your own schedule, instead of complying with the timetable ordered by the court. Here is what the judge said, and I quote, "I'd like to see some kind of manifestation by the people that administer these statutes that they realize they are under the constraints of a court order and accordingly are going to make a good faith effort to comply." It's true that the judge did not take the extreme step of actually holding you in contempt of court, but this is what the judge went on to say, and I quote the judge, "We do find, though, that the court order has been violated in many important respects, and that we're not all convinced that these violations will be taken care of and eventually eliminated without the coercive power of the court." So the judge said very clearly that you violated the court orders in many important respects. He used the word violated. He was concerned that you were still not making the good faith efforts to comply. He was clearly threatening you with contempt. He was obviously pretty upset with you. What do you think he meant when he said he might have to use the coercive power of the court to get you to comply with the court order?
Senator, when I responded to Senator DeConcini, I think I also noted, and I did not go back and review the transcript, that I had not had an opportunity to review the entirety of the record or any orders by the court. That's been, again, now about 10 years. With respect to what the court was doing, the petition that was filed with the court was filed prior to my going to the Office for Civil Rights. I went to the Office of Civil Rights, I believe, in May of 1981. That was filed sometime, I believe, in February or March. I can't remember exactly when. The office had never been able to comply with those time frames under the consent decree, and indeed we improved in the brief time that I was there. I actually became assistant secretary in July, even though I was there before. I was actually sworn in July of 1981. And during that brief period, we were able to improve the performance to comply with the time frames. But we certainly did better than the individuals prior to us, but still were not able to comply. And we devoted 95% of our resources in an attempt to comply. what I suggested to Senator DeConcini is perhaps that I did not, I should have gone back and perhaps looked at some additional steps or in communications with the court in order to prevent the matter from reaching the point where it could be suggested that I was in any way not acting in good faith or in defiance of the court order.
Well, didn't the judge draw some conclusion in terms of your performance and the previous official's performance?
And I have not reviewed the record, Senator. It's been quite some time.
Well, I believe it did, but you can correct the record and take a look at it and make a comment on it. The judge may not have taken the harsh step of holding you in contempt, but he did take other steps contrary to what told Senator DeConcini. He set a deadline for the completion of a study that you had told the court you needed prior to taking any action. He set a deadline for both parties to consider the results of the study to agree on the revisions of the court order timeframes, if any were necessary. Also, you had told the court and told the committee this week that you had expedited the study when you arrived at the Office of Civil Rights. In both instances, you cited this as an example that you were making your best effort to comply with the court order. I would not say the judge thought making the best effort in marking you in contempt, but he did take other steps contrary to what told Senator DeConcini. He set a deadline for the completion of a study that you had told the court you needed prior to taking any action. He set a deadline for both parties to consider the results of the study to agree on the revisions of the court order timeframes, if any were necessary. Also, you had told the court and told the committee this week that you had expedited the study when you arrived at the Office of Civil Rights. In both instances, you cited this as an example that you were making your best effort to comply with the court order. I would not say the judge thought making the best effort in March of '82, hearing your lawyer commented that you had told the court you expected the study to be completed within the next month or two, but the judge responded, I think he kind of hedged on that prediction. I think if we were going to leave it up to Mr. Thomas, you might not get it this year. That's what the judge said. He sounds pretty skeptical that you were going to comply with the court order.
As I indicated, Senator, the study that we were referring to was begun prior to my arriving at the Office for Civil Rights. And it, as I remember, and again, it's been quite some time, it had been scheduled for completion at one point, and I expedited the schedule so that we could have that study in place so that we could make the appropriate changes consistent with that study.
This is what the judge stated in reference to your predecessor, Mr. Fetal. I contrasted Mr. Fetal on the one hand, who was sitting in the same position Mr. Thomas was 4 years ago, 4.5 years ago. Mr. Thomas and I contrasted Ms. Shong and Mr. Rugo. It seems the difference between these two people, the difference between day and night. Now, Rugo admitted that they were behind in their work as far as the Office of Federal Contract Compliance was concerned, but he manifested an active interest in improving the machinery. Things weren't getting any worse. I think they were probably better. And while things weren't completely in accordance with the time frames, Mr. Fetal went out of office in the fall of '78 or '79. This was the fall of '79. Things were on the way to being improved, whereas at the time he took over, things were in bad shape. That's my basic problem. I don't like to hold people in contempt. On the other hand, I'd like to see some kind of manifestation by the people that administer these statutes as they realize they are under the constraints of a court order and accordingly are going to make a good faith effort to comply. You can put in the record whenever you get a chance to examine the transcript.
Well, he was not my immediate predecessor. My immediate predecessor was Cindy Brown. The difficulty that we face, Senator, that I did not allude to, and is one that the office continued to labor under, and I think it was an important difficulty, is that when the Department of Education was created out of HEW, to my knowledge, the Department of Education Office for Civil Rights had about 80% of the work and 60% of the staff, and was inundated. I think it was in a much different position from the HEW staff. But that's something that is a part of what you inherit when you move into a department, and it was a very difficult problem. The assurance that I made and that I make here, and it's a very firm one, is that we attempted to do all we could to dig ourselves out from under the workload. That is quite a bit different in terms of accomplishing than it was, say, at EEOC, where I was not a part of a larger department that controlled decisions over the deployment of personnel and budgets.
Well, did you complain about the staff and the resources?
Absolutely. Yeah. In fact, internally, I complained as my successors complained. But there were competing interests. As you remember, at that time, the Department of Education itself, the full department, was undergoing a RIF. And though the OCR did not have the same budgetary constraints, it was held to the same standards and not permitted, for example, to hire staff.
Let me move on to another area. During your opening statement, you praised civil rights leaders for having changed society, and you stated, "I have benefited greatly from your efforts, but for them, there would have been no road to travel." But in the past, you've condemned those same civil rights leaders. In 5 different speeches, 1985, for example, you denounced, and I quote, "a civil rights community wallowing in self-delusion and pulling the public with it." The end of quote. You omitted that phrase from only 2 speeches during this period, only 2 speeches you gave to predominantly black audiences. What did you mean when you said the civil rights community was wallowing in self-delusion and pulling the public with it?
Well, let me make 2 points there, Senator. I have many other speeches in which I extensively praised the civil rights community and its efforts speeches on the Reverend Martin Luther King, speeches with respect to the NAACP, many organizations, and I've always given credit concerning the efforts and the major contributions of the civil rights movement and the civil rights groups to our society. The difficulties that we had during the 80s was an important difficulty, and that was this, that there was, to my way of thinking, a need to begin to debate anew some old problems and to begin to look at them with fresh ideas. What you see in those speeches are my frustration, or is my frustration, that debate never took place. Instead, you see a similar frustration expressed to the conservatives in the Heritage Foundation speech. Rather than ultimately sitting down and beginning to try to work out the problems, we were spending our time yelling across the table at each other. I had hoped that would not have been the case during the 80s. And as we all know, much to our chagrin, and I think to the chagrin of anyone who was involved, that did not occur.
Well, then in 1987 interview with the Reason magazine, you were asked whether there were any areas where the NAACP and the civil rights established were doing good, and you interrupted the questioner to respond no. In the interview, you asked none. You said none that I can think of. In at least 3 speeches, you said members of the civil rights movement had given in to the cult mentality and childish obedience. This is your quote, which hypnotizes blacks into a mindless political trance. And again, in 1988, here's a quote, "We must now not merely be critical of the many blunders and follies that have occurred in the practice of civil rights. We must show how our reliance on American principle produces better results than those of our enemies." Pretty powerful stuff, calling leaders in the civil rights movement the results of those of our enemies. And then in 1987, you publicly castigated civil rights leaders who, and I quote, "bitch, bitch, bitch, moan and whine."
I think that
the point that I hear the kind of debate you were trying to begin, I remember the time also as most of those leaders very much involved in working with Congress and the extension of the Voter Right Act of 1982, when we had initial opposition. William French Smith, right before this committee, expressed his opposition. He's going to recommend it to President Reagan, veto it. I can remember the work that was done by the civil rights groups in 1984, 1985, 1986, when we were trying to overrule the Grove City case, which affected all federal funding, whether it could be used in terms of discriminatory purposes. I remember the work that many of them were done in terms of the sanctions against South Africa. I know you have a different opinion from many of the civil rights leaders, although that opinion was different, evidently, from what you had at Holy Cross, where you supported disengagement and the economic sanctions. They were very much involved in overriding a presidential veto. And I remember the civil rights leadership in 1988, 1987, 1988, when for the first time we worked out fair housing legislation, which had been basically stalemated in the Congress. These are major kinds of proposals that they're very, very much involved in. And what we find is the series of extremely critical comments about all. And then the time is moving on. You had in a 1987 interview, you stated that I find exasperating and incomprehensible the assault on the bicentennial, the founding of the Constitution itself by Justice Thurgood Marshall. His indictment of the framers alienates all Americans, not just black Americans. That's a strong attack on Justice Marshall. He was criticizing the original Constitution for accepting slavery.
Thank you, Senator. Let me go back, and I'll try to cast this generally. I will not attempt to go through each one of those seriatim unless you would want me to. I think in the interview, my point was that I was the wrong person to ask with respect to comments about the existing civil rights community because of the manner in which the civil rights community had treated me, and that I'm no more or less human than anyone else, that there was serious disagreement, and I don't think that the disagreements were at the level that they should have been, and I suggested that. I attempted to conduct myself in a way that we could have a constructive debate, and I reiterate the point that I have major speeches throughout my tenure that are very, very supportive and very strongly indicate my allegiance to the civil rights community. But I don't think that that civil rights, and to the civil rights movement, but I don't think that that allegiance and that support should undermine the ability to disagree. And the comment that I made with respect to the unanimity, the homogeneity of our points of views, I think are important. I think that there is a need for debate. I've said from my early speeches in 1981 that it is important. These issues are so difficult and the problems are so bad that we need all of the talent, that we needed all of the ideas possible, not just one point of view. I did not feel that that opportunity ever occurred, or that we had the chance, or I had the chance personally to engage in that debate. And I thought it was a lost opportunity, and I said it on both sides of the aisle with respect to the civil rights community as well as with respect to the Reagan administration.
Well, it would appear, and the record will show, whether these were expressions of disagreement or strong negative statements. Judge Thomas, I continue to have serious concerns about your nomination. In your speeches and articles, you've taken many strong positions, but again and again you've asked this committee to ignore the record you compiled over a decade. On natural law, despite your previous clear advocacy of using natural law in construing the Constitution, you now tell us that you don't see a role for the use of natural law in constitutional adjudication. On the right to privacy, you've walked away from your record and statements. You now say that you support a right to privacy, but you refuse to comment on its controversial applications. On abortion, you've explained away your strong praise for Louis Lerman's extreme article supporting the right to life position, and said you just mentioned the article in the hope that a right-wing audience would be more inclined to support enforcement of civil rights. You ask us to believe that an intelligent and outspoken person like yourself has never discussed Roe v. Wade with another human being. You ask us to be confident that you will enforce a woman's right to be free from gender discrimination, despite your prior stereotype statements about women and work. You have abandoned your previous statements that business rights are as important as individual rights or any other right. You now claim you're satisfied with the Supreme Court decisions that give less importance to business rights and greater importance to individual rights. You've criticized Supreme Court's decisions protecting voting rights and sustaining the power of Congress to appoint independent prosecutors to investigate wrongdoing in the executive branch. Now you seem to be supporting those positions. You trashed the leaders of the civil rights movement in many speeches, but now you emphasize your debt to them. You trashed Oliver Wendell Holmes in one of your speeches, but last Friday you called him a giant in the law. You've harshly criticized Congress. As an executive branch official in the Department of Education, you were on the verge of being held in contempt of a federal court for failing to enforce civil rights laws. You urge lower courts to follow a Supreme Court dissenting opinion restricting job opportunities for women instead of the court's majority opinion expanding those opportunities. The vanishing views of Judge Thomas have become a major issue in these hearings. If nominees can blithely disavow controversial positions taken in the past, nominees can say those positions are merely philosophical musings or policy views or advocacy. If we permit them to dismiss views full of sound and fury as signifying nothing, we're abdicating our constitutional role in the advice and consent process. Some say that the Senate should consider only the nominee's qualifications and not his ideological views. But the Constitution gives the Senate a shared role with the President in the appointment of justices to the federal courts, and for very good reason. The Supreme Court thrives on the diversity of views of 9 justices who comprise it. It's our system of checks and balances. The role of the Senate is one of the most important checks on the power of the President to pack the court with appointees who share a single, one-dimensional view of the Constitution. When ideology is the paramount consideration of the President selecting a nominee, the Senate is entitled to take ideology into account in the confirmation process and to reject any nominee whose views are too extreme or outside the mainstream. As we move to the next stage of these hearings, I continue to have major concerns about your nomination, about your commitment to the fundamental rights and liberties at the heart of the Constitution and our democracy. This is no time to turn back. Thank you, Mr. Chairman.
Thank you very much. Now, where we are at this moment is that all Republican senators have had a third round, and we should be just going down the row here. But Senator Grassley, who didn't complete a third round last week, apparently has a couple minutes he'd like to use now. Is that correct?
At least not more than 5.
Okay. Well, if it's all right with the senator from Vermont, if we yield to the senator from... I mean, everybody will have more time. Everybody will have more time if they want it on the Republican side. I'm just trying to make sure we're doing this the way we're...
Senator Brown may want to.
Sure, Senator Brown is entitled to any time he wants, and we'll do that. I just wanted to make sure that people who have had a chance to ask 3 times already yield to those who haven't only asked twice. Senator Brown's only asked twice, so he'll get it. At any rate, after all that malarkey, why don't I just yield to the senator from Iowa for whatever questions he has, and then we'll go to the senator from Vermont.
Well, Mr. Chairman, my point...
Excuse me, Senator, I've been asked a question. Are we going to be breaking for lunch? I think that's going to be inescapable. The question is whether we break immediately after senator from Vermont, and I think that depends on how long the senator from Iowa goes, and he has the right to go long if he wants, or whether we break after senator from Alabama. And that being the case, we'd be down to very few minutes after that. But we're probably going to have to break for lunch, and then we'll do a very short break, meaning an hour, not an hour and a half, when that time comes. But let's see how far we get right now.
Well, Mr. Chairman, I take some time now just to, for further clarification more than anything else. And I had previously discussed, for the committee's benefit more so than to question the judge about the Adams versus Bell matter, and I thought maybe it'd be closed, but it's apparent that it's not closed. Last week I'd asked that the transcript of the proceedings be printed in the record, and you said it'd be made available, and at the time I thought that that would be sufficient. But now I think it's only fair that the transcript and the judge's order in which Judge Thomas was not held in contempt be printed in the public record. And I think that it should be clear that Judge Thomas, as I said previously, and as I laid out in a factual record, that Judge Thomas only inherited a very difficult situation and in no way intentionally violated the law. So I would like to have that printed in the record if I could, Mr. Chairman.
Without objection, it will be printed in the record.
And I would also like to correct what seems to be wrong impression here regarding Judge Thomas's relationship with civil rights groups and leaders. In October 23rd, 82 speech before the Maryland Conference of the NAACP, as the then newly installed chairman of the EEOC, here's something that I thought Judge Thomas said well that expresses his working relationship. I would like to talk with you about why I believe that you are the group that can truly make a difference for blacks in this country. What I think of the challenges will be in the future, and what we are doing at the federal level to address the problems of discrimination. The pervasive problem of racial discrimination and prejudice has defied short-term solution. The struggle against discrimination is more a marathon than short sprint. Political parties have come and gone, leaving behind them the failures of their quick fixes. Promises have been made and broken, but one group, the NAACP, has remained steadfast in the fight against this awful social cancer called racial discrimination. The NAACP has a history of which we can all be proud. From its inception in 1909 until today, the work this organization has done in the area of civil rights is unmatched by any other such group. At each turn in the development of blacks in this country, the NAACP has been there to meet the challenges, end of quote. Judge Thomas has often acknowledged the significant role of civil rights movements and how he personally has benefited from it. In volume 21 of the Integrated Education publication in 1983, Judge Thomas wrote, and I quote, "Many of us have walked through doors opened by civil rights leaders. Now you must see that others do the same," end of quote. In a January 18th, 83 speech at the Wharton School of Business in Philadelphia, Judge Thomas said, and I quote, "As a child growing up in the rural South during the 1950s, I felt the pain of racial discrimination. I will never forget that pain. Coming of age in the 60s, I also experienced the progress brought about as a result of the civil rights movement. Without that movement and the laws it's inspired, I am certain that I would not be here tonight," end of quote. An October 21, 82 speech to the 3rd Annual Metropolitan Washington Board of Trade EEO Conference, Judge Thomas described himself as, and quote, "a beneficiary of the civil rights movement," end of quote. April 7, 84 speech at the Yale Law School Black Law Students Association Conference, Judge Thomas noted the freedom movement of black Americans was not a sudden development, but, and I quote, "had been like a flame smoldering in the brush, igniting here, catching there, burning for a long, long time before someone had finally shouted, 'Fire!'" End of quote. He asked, in effect, who was responsible for this? Then Judge Thomas went through a litany of people and events that helped fan the flames of black freedom. He asked in part whether it was the founders of, and these are quotes, "the founders of the NAACP or the surge of pride which black folks felt as they huddled around their ghetto radios to hear Joe Louis preaching equality with his fists, or hear Jesse Owens humbling Hitler with his feet." Was it A. Philip Randolph mobilizing 100,000 blacks ready to march on Washington in 1941, and FDI hurriedly signing Executive Order 8802 banning discrimination in war industries and apprenticeship programs? Or the 99th Pursuit Squadron, trained in segregated units at Tuskegee, flying like demons in the death struggle high over Italy? Was it Rosa Parks who said no, she wouldn't move, and Daisy Banks who said yes, black children would go to Central High School? Or the three men who had been the black man's embodiment of Blitzkrieg, the most phenomenal legal brains ever combined in one century for the onslaught against injustice: Charles Houston, William Hastie, Thurgood Marshall? Or a group of students who said, we've had enough. I mean, what's so sacred about a sandwich, Jack? Or men named Warren Frankfurter Black Douglas, who read the Bill of Rights and believed. I realize, Judge Thomas, and for members of this committee, it may seem more newsworthy to report the judge's remarks only when they have been critical of traditional civil rights leadership, and I realize some of his critics who object to his expressed views against reverse discrimination and preference wish to make him look ungrateful, but it's a false portrait, a caricature being drawn. So, Judge Thomas, I think you have a lot to be proud of in not only your statements but your actions in support of efforts of others in the civil rights community to carry the ball and run with it. And I think you've adequately recognized their contribution, and I thank you for it. And that's the end of the time that I'll use now, Mr. Chairman.
Well, thank you, Senator. After conferring with Judge Thomas's spokespersons in the break here, it seems appropriate that we will take a break for lunch now. Now, let me just give everyone a heads up on where we're going to go from here. We will go to Senator Leahy next, unless Senator Metzenbaum comes back and claims his 15 minutes. And then what we'll do is, I hope we can, as I count the time, we should be able to finish everything by 4 o'clock today with regard to Judge Thomas. We will then move to the ABA today, and they will probably move to the first panel of witnesses. Well, we will move to at least one other panel, maybe two, and tonight we will go with the public witnesses until sometime close to 6:30. To try to move this along, because we are going to have, we'll end early tomorrow night and we will not be in session on Wednesday. So we'll see how much we can move along and catch up at the other end here. So now let me ask, we will break for lunch until 1:30, which time in all probability we'll resume with if it's convenient for Senator Leahy,
I'll be prepared to start my question right at 1:30 if that's
yes,
the chair
okay.
wants.
We'll start at 1:30. We will recess to 1:30.
It's true, Biden has looked old forever. It's a little. So, I mean, we can just go onward, see how far we can get today. It's after lunch. Fast forward. I like this. I like the stuff that still holds up, you know, because Chevron was just. I don't know,
From Washington, D.C., this is
You wouldn't say that Chevron was overturned. I would say that it's now, you know, in question. I don't know. We have to see what the agencies do, what the courts end up doing. And they asked about the Korean War. I actually didn't hear his response, you know, whether it was a war or a conflict. they asked him about minimum wage and how he thinks everybody should get a minimum wage, but it's a complicated issue. That I think he was the Equal Employment, the chair of the Equal Employment Opportunity Commission, I believe. Other things that came up was, issues surrounding sexual harassment and reporting standards. I think you might call that a little bit of a harbinger. I don't think he knows at this point the Anita Hill of it all is coming in 2 weeks. She's gonna talk to the press. That's a lot of people. They're interested in that. And then, how he's kind of, at one time in his life, he was very much for civil rights and venerated their leaders, and then later on he denounced them. So these are, yes, the EEOC. He was the chair of the EEOC. There's too many acronyms in the government, though, Too many.
That women were not
God.
going on at the same
said
time.
We're going to give Metzenbaum another
Before
15
the break,
minutes, and I should have known.
Thank you very much, Mr. Chairman. Judge Thomas. Judge Thomas, before the break this morning, I was inquiring about the EEOC's failure for 6 years to process sex discrimination charges involving fetal protection policies. I'm frank to say that I regret that I missed your ensuing discussion of this issue with Senator Hatch, and as has been publicly stated, I missed it only because I'm also sitting on the Gates nomination hearings, which are going on at the same time. But as I'm informed by my staff, you agreed with Senator Hatch's statement that, quote, women were not prejudiced by the EEOC's failure to act on this issue for over 6 years while you were chairman. Judge Thomas, I simply cannot accept the idea that women were not harmed by the agency's default on this issue. The women who lost their jobs due to sex discrimination were certainly harmed. Some of them didn't get their jobs back for 10 years, and some of them never got their jobs back at all. Had you acted in a timely manner to resolve their charges, they surely would have been spared much of this harm. And had the EEOC declared fetal protection policies to be illegal in 1982, as it did in 1991 after your departure, the women who were forced to undergo sterilization in order to keep their jobs might have been spared that terrible outcome. Judge Thomas, you pointed out that women were free to file their own lawsuits challenging fetal protection policies. The women who lost their jobs or were sterilized as a result of fetal protection policies were blue-collar women working at an hourly wage. These women came to the EEOC because they could not afford to file their own cases, or they needed assistance with the complex issues involved. These women sought the help of the EEOC in fighting for their rights. That's why the agency is there. But under your direction, it didn't hear the cases. It turned its back on these women. My question to you is, do you really believe that these women did not have their rights prejudiced at all simply because they retained their right to bring a private lawsuit?
Senator, the point that I thought Senator Hatch was making was that the right to bring a lawsuit or to engage in litigation continued to exist and did not expire. I don't think either one of us intended to suggest that individuals who have to wait for long periods of time to resolve these issues aren't in some way and to some extent prejudiced to that degree. The point with respect to what we did during my tenure, I think, has to be refocused in this way. In thinking about this, the issue where we eventually arrived in developing a policy, I believe the BFOQ approach was originally rejected prior to my going to EEOC, and there was significant debate about that. We attempted to resolve the issue in what I think was an appropriate way. It didn't happen as fast as most of us would like it, but it was a very, very difficult issue. And it was one, the rulemaking and the final resolution that you're talking about or that you commented on was one that was developed during my tenure, although finalized after my tenure. And it, again, was something that in these difficult areas you would hope to have been able to done a lot quicker or done in a more expeditious way. But this was one of the most difficult issues we wrestled with.
Well, before the break this morning, you stated in response to my question that it took 6 years for the EEOC to take action on charges involving fetal protection policies because you were faced with difficult issues outside its area of expertise. However, Judge Thomas, even if these charges did present difficult issues, that would hardly justify taking no action on them for so many years. In addition, although some of the charges may have turned on complex scientific issues, many others represented clear violations of Title VII. For example, in one case, a female job applicant was denied a job requiring exposure to lead due to fetal health risks which might arise if she became pregnant. The employer's personnel manager told her that she wouldn't like plant work anyway, that plant work would be too dirty for her, and that he could use a pretty face in his office. The applicant, understandably, filed a discrimination charge in 1981. The commission investigated the charge, but took no action to resolve it for 8 years. In 1989, the commission closed the case because it was unable to locate the charging party. Now, some charges filed with the commission languished even though the employer had offered no evidence at all to back up its discriminatory assumptions regarding the health risks posed by the hazard in question. In other cases involving X-ray technicians, the commission had already issued a decision prior to your tenure finding a violation based on parallel facts. I don't dispute that some of these issues may have raised difficult issues, but do you really believe that that justifies the EEOC's total inaction for 6 years? One has to say, why did it take so long for any action at all to occur?
Senator, as I've indicated, I think that the agency during my tenure could not be said not to have been taking any action. The results may not have occurred in a way that that we would have liked it to have occurred as expeditious as possible. But to say that we took no action is incorrect, I believe. The agency, the commissioners, including myself, attempted to review this particular policy in a professional way, in a way that would protect the rights of women. We recognized, and there was disagreement among staff as well as commissioners, and I think even within the government, we recognized that this was a difficult issue that involved scientific as well as health problems or health concerns, and we attempted to resolve it in a way that took those factors into consideration.
Judge Thomas, I must also take issue with Senator Hatch's suggestion that in the Johnson Controls decision, the Supreme Court, quote, adopted basically your ideas on fetal protection and carried them a little further. Those are quotes. As Senator Hatch pointed out, your position in the EEOC's 1988 policy guidance was that where a substantial risk to a fetus or potential fetus existed, employers could use fetal protection policies which applied only to women. What Senator Hatch did not mention is that your 1988 policy allowed women to be excluded from jobs even if those women were fully able to perform their jobs. But the Supreme Court expressly rejected that position in Johnson Controls, holding that these policies could never be justified by reference to the well-being of a fetus or potential fetus. In short, it took the EEO 6 years under your tenure to develop a position that the Supreme Court rejected out of hand.
I could be on my recollection, if my recollection serves me right, Senator. I think Senator Hatch must have been referring to, I think, the 1990 policy. Again, I don't have that in front of me, but I think the 1990 policy was consistent with the Supreme Court decision. I would have to go back and look at that. I'm, again, operating just off memory.
Judge Thomason, the facts actually speak for themselves. This was an issue of great significance to women in the workplace. According to the Bureau of National Affairs, as many as 15 to 20 million jobs may involve reproductive hazards, and thus could have been affected by exclusionary fetal protection policies. Given that fact, it is not surprising that one federal judge said that the Johnson Controls case was, quote, likely to be the most important sex discrimination case since the enactment of Title VII. You were sworn to protect the rights of the millions of working women in this country against employment practices that completely barred them from high-paying industrial jobs. Frankly, Judge Thomas, based upon the facts, not on opinion, but based upon the facts, it would appear that instead of protecting these women, you abandoned them. For most of the 1980s, you refused to resolve over 100 discrimination charges that had accumulated at Commission headquarters. In addition, when you finally began to act, you sold women short by allowing employers to adopt facially discriminatory policies that excluded women who were fully capable of performing their jobs. In this year's Johnson's Control decision, the Rehnquist Supreme Court concluded that employers have no business depriving women of their jobs in the name of protecting non-existent future fetuses. The court expressly held that, quote, decisions about the welfare of future children must be left to the parents who conceive, bear, support, and raise them, rather than to the employers who hire those parents. That's the court's language, end of quote. 3 months ago, the EEOC finally took the position that policies that exclude members of one sex from a workplace for the purpose of protecting fetuses cannot be justified under Title VII, end of quote. The EEOC conceivably, probably, should have reached that conclusion 10 years ago. You had an opportunity to make it occur. You didn't. The EEO's failure to protect women, apparently at your direction, gives me and millions of American women and men cause for concern, because it appears that on the basis of the facts, you didn't protect their rights when it was your sworn responsibility to do so. And I'm very worried that you won't protect their rights as a member of the Supreme Court. Now, Judge Thomas, as I reflected on our last 4 days of hearings, and as I reflect back on your answers to my questions this morning, I feel compelled to repeat a point I have made to you. I am struck and can't figure out a reason, can't comprehend the number of times in which you suggest that this committee should discount past statements which you have made. For example, you gave speeches to lawyers and wrote articles in law journals advocating the use of natural law, subject to which the chairman has addressed himself quite extensively. But now you say that you never meant to suggest that natural law should be used in deciding cases. You have condemned aggressive legislative oversight, characterized Congress as unprincipled and out of control, and commended Justice Scalia's narrow vision of congressional power under the Separation of Powers Clause. But now you say that those remarks were just part of the normal tension and give and take between Congress and the executive branch. And on other issues such as economic rights, the minimum wage, and affirmative action, there's a conflict between your testimony to the committee and statements which you have made in the past. But in the area of abortion, one of the most important issues facing this nation, one that has been discussed and about which you've been asked at great length. It's in that area that you have most seriously sought to distance yourself from your past record. To the millions of American women who are wondering where you stand on that critical issue, your answer is, trust me, my mind is open. I don't have a position or even an opinion on the issue of abortion. Judge Thomas, that's just incredulous. It's difficult for millions of Americans, whether they are pro-choice or pro-right to life, to accept. You have a record in this area. You simply don't want us to take account of it. You're asking us to believe that you didn't really mean it when you said Lehrman's anti-choice polemic was splendid. You're asking us to believe that you didn't really mean it when you signed onto a report that criticized Roe and other pro-choice decisions. You're asking us not to worry that you criticized a key constitutional argument supporting a woman's right to choose. You're asking us not to worry that you were on the editorial board of a journal that has only published articles on the abortion issue which vehemently attack a woman's right to choose. You're asking us to ignore the fact that your nomination is championed by anti-abortion groups and that you were selected by a president who has pledged to appoint justices who will overturn Roe. And you are asking us not to be concerned that you, like other nominees, have gone onto the court and undermined the right to choose, have singled out this particular subject for silence. Judge, I cannot ignore your past statements on the abortion issue and on other critical legal issues and policy issues. I cannot accept the idea that we should give little weight to what you said or did before going on the bench. I reject the notion that what you said or did about certain issues before becoming a judge bears no relation whatsoever to what you will do with respect to those issues once you're on the bench. And I cannot accept your suggestion that we should discount some of your most controversial statements, such as your praise of the Lehrman article or your condemnation of the Morrison case, on the grounds that you didn't endorse or agree with what you were saying. That explanation only raises more questions than it answers. The bottom line is this, Judge. You have a record, and I believe this committee and the Senate must evaluate your nomination based upon that record and based upon the way in which you have discussed that record with this committee. Thank you, Judge Thomas. Thank you, Mr. Chairman.
Thank you very much. Senator Brown would be next if he were here, but I yield to Senator Leahy.
Thank you, Mr. Chairman. Judge Thomas, I'm told that at least for your testimony, the end is near. The matter that you're I was going to say you probably see with mixed emotions, but I doubt that'd be a fair statement. You're probably happy to have it end. I hope you and your family had a pleasant weekend. I must admit, while I was up in Vermont with my family, I heard more discussion about you than I've heard ever since your nomination. Came up more people came up to me in grocery stores and at gas stations and on the street, virtually every place I was, and in fact, all but one person I think I talked with during the weekend mentioned you either for or against you. I told them what I've told others here, that while I've tried to be, and I think I've been here just about 95% of the time you've testified or been here, I've done this so that I might know you better. And I'm willing to spend the time here with you. I won't with many of those who will speak either for or against you. I will read their statements, but they're not the ones about to be voted on one way or the other. You are. And so I try to do it to get to know you better. And I want to know how you think, what you consider the most important in the law or cases, what kind of justice you would be if confirmed, how qualified you are. In many ways, I don't really have those answers. Probably never will, even at the time you finish testifying today. Apparently, a judgment has been made either by you or your advisors or in conjunction with each other, I don't know, not to answer many questions for whatever reason. And you stated a number of instances when people suggested you weren't answering the questions, you stated your reasons why. So I'll reread the transcript to see if a better view of you develops. One of your advisors, Senator Danforth, feels he knows you very well. I'm sure he does, and he's had years and years of getting to know you, and all of us, both sides of the aisle, have the greatest respect for Senator Danforth, but we haven't had that experience with you. So we've had to, every senator has had to make up his or her mind based on what you said or not said here. And I said to somebody this noon that I wanted to kind of look into the window of your soul if I could, although I find the shade down quite a ways, and that may be me. That may be ineptitude on my part. That may be design on yours. That may be the ships in the night. I don't know. But let me ask you a few more questions, and while I could have dozens and dozens more beyond the ones I will ask, I suspect that I might not know more than I do if I were to ask them. So let me just take a few. And first one, even though you've been asked a number of questions on natural law, I find that I get asked a lot of questions about that, again, when I was home in Vermont, to people just exactly what is meant by it or what you mean by it. You've testified here that natural law plays no role in constitutional adjudication. You told Senator Hatch on Tuesday, I believe it was, that a constitutional amendment was required to outlaw slavery. Now, does that mean that you believe that the Dred Scott case, which was decided before the 13th and the 14th and the 15th Amendment were enacted, was correctly decided?
I don't think I suggested...
It was decided.
No, I don't think I've suggested that and didn't analyze it in that way. But I believe the question there was whether or not, since he was not an escaped slave, question of whether or not he enjoyed the privileges and immunities of a citizen, and I think it would have been analyzed a bit differently. But my own reaction to that is that it was not correctly decided, and I've not gone back and redecided it.
Well, have you not argued that Justice Taney failed to take into consideration the natural law principles in the Declaration of Independence, particularly those that all men are created equal?
I don't have that before me, and I don't have the analysis before me, Senator, but I think that I could be wrong on this. I think that was a privileges and immunities case.
Mm-hmm. But did you argue that Justice Taney failed to take into account natural law principles in the Declaration of Independence?
No, I think, and again, I don't have that before me, but I think the reference was to the founders' understanding of natural law and what they were including in the Declaration or in the Constitution.
Did you tell Senator Hatch that the constitutional amendment was required to outlaw slavery?
I did. But the issue there was a different issue. I think the issue was a black individual who had been taken to a non-slave territory rather than having escaped to that territory. That would have been the similar arguments that were made by individuals who were free blacks and what their rights were.
Should Justice Taney have used natural law in the Dred Scott case?
I think he should have, again, read the Constitution and attempted to discern what the founders meant in drafting the Constitution.
But if he did that before the 13th, 14th, 15th Amendment, would he not have had to uphold slavery? I mean, slavery was allowed at the time the Constitution was drafted. Was
I think the separate issue is if the individual, and a complicating issue is if you're in a state that does not have slavery or in which slavery is outlawed.
Judge, let me quote from a couple of your speeches. Wake Forest, in April of 1988, you said that, quote, I thought that Ollie North did the most effective job of exposing congressional irresponsibility. He forced their hand, revealed the extent to which their public persona is fake. You said then, and a year later, as Lieutenant Colonel Oliver North made perfectly clear last summer, it is Congress that's out of control. Now, don't want to debate the issue of how you felt and what you said at those times, but I take those particular statements because last year, as a judge in the Court of Appeals, you ruled in favor of Colonel North in his criminal case. You voted, in effect, to sustain the opinion of the panel which had overturned his conviction on the ground that it was tainted by the use of congressionally immunized testimony. Now, the reason I mentioned both your vote in that case, and you were with a substantial majority, I believe it was an 8-2 majority, and your earlier statements, is because I've heard you say it over and over again when we've asked you questions here that you were concerned in giving us an answer that you might affect judicial impartiality, and stating in effect that you did not want to preclude yourself from cases that might come before the Supreme Court on the question of impartiality because of what you said here. Did you ever consider disqualifying yourself from sitting in judgment on Colonel North's case on the grounds of either the strong support that you expressed for him in 1988 or your criticism of the Iran-Contra congressional hearings?
Senator, first of all, let me address the statement itself. As I've indicated, my statement was in reference to something that happens sometimes with respect to oversight hearings, or I guess in the political environment, and that is that substantive hearings become overly publicized or overly politicized. And in this instance, I indicated, and this is the way I felt, that in giving that speech, Colonel North exploited that to his own advantage. I at no time expressed, and in fact, in reflecting on my feelings toward him during that time, my own view was that if he lied to Congress or that he had engaged in any kind of unlawful conduct, then he should suffer the consequences. At no time did I condone that. On the Court of Appeals, the issue was a rehearing petition, whether or not that case should be reheard en banc. And I didn't feel that I was in any way or anything other than impartial in considering that.
So the answer to my question is no.
I did not. I felt that I had not expressed any opinion on his culpability or on his criminal conduct.
But I want to make sure I understand the question. The answer to my question is no.
That's right.
Okay. Do you think that there is a core of political speech that is entitled to greater constitutional protection than other forms of speech?
I think that, Senator, the value that we place on speech, on whether it's freedom of the press or whether it's on freedom to engage in discussions about politics or whether it's expressive conduct, we see those as, and the court has treated those as fundamental rights and has protected those accordingly.
Is all speech the same, though? Is all speech given exactly the same constitutional protection?
Well, I think the court, of course, has not accorded the same protection of speech to commercial speech, for example. But the issues that have faced the court have usually involved whether or not the difficult issues have involved expressive conduct as opposed to pure speech.
What about, oh, I'm sorry.
And the exercise that the court has gone through has in essence been whether or not the government or the state can in any way regulate that expressive conduct and under what circumstances. In cases, for example, like O'Brien or the cases such as Texas versus Johnson, the flag burning case.
Well, you don't, you're not saying then by any stretch that only political speech is protected. I mean, there's a lot of other speech beyond political speech is protected by the First Amendment. I realize what you said about the expressive forms, but I'm talking about just speech now.
Senator, I have I've not analyzed every single speech case, but my own value would be to protect all the entire amendment in all of its fullness, and not to find ways to creatively read out that protection. I think it's important that we protect all of the amendment.
But now, for example, if you had non-political speech, like say a scientific debate, that'd be protected by First Amendment.
Well, I think that
I'm trying to get you to a specific case. You understand, Judge? I just want to make sure we differentiate between the types of speech. But a scientific debate, First Amendment protections.
Well, I think that speech, we value all of our speech. What I'm trying to say is I don't limit and see no reason, and haven't seen the court limit our freedom of speech to whether or not we're talking about science or whether we're talking about politics. Certainly the court has attempted to accord protection to speech such as, for example, the most recent case being the Texas versus Johnson flag burning case.
Now, in that case, that was a 5-4 decision, as I recall. They upheld, or they refused to uphold a conviction on the basis that the flag burning was a political statement. Is that a fair shorthand?
No, it was expressive conduct.
Expressive conduct?
Expressive conduct. That the individual was making a statement, a political statement, in burning the flag, and that was protected by the First Amendment. And the analysis normally is whether or not the government can in some way control the conduct or regulate the conduct. Whether the government, if it's expressive conduct, has a compelling interest in regulating that conduct.
Do you agree with the Johnson case?
Again, Senator, I have not, I think it's inappropriate for me to express agreement or disagreement, but I agree that we certainly should, that expressive conduct should be protected by the First Amendment. And I think that the difficulty for the court has been to what extent can it be regulated, not whether or not it should be protected.
You would, or would it be safe to say you draw the line at certain kind of expressive conduct? Suppose somebody says, I'm going to make a political statement by driving 95 miles an hour down Constitution Avenue. Would that, might you say that might stretch the First Amendment guarantees a tad far?
I think the analysis would be along the lines of whether or not the government has an interest, a compelling interest in regulating this conduct. And I think that we would probably both, and that's an extreme example, we would both have some difficulty with the government not regulating someone speeding down Pennsylvania Avenue at 95 miles an hour. Although at times you feel in some cabs that you're going 95 miles an hour along Pennsylvania Avenue.
In New York Times versus Sullivan, which is sort of I think we could all kind of agree is the benchmark libel case, the court held an official couldn't recover damages unless he could prove that a public official couldn't recover damages unless he could prove that the defamatory information was made with actual malice. Does that standard provide sufficient protection for public figures in your mind?
I think I guess I haven't looked at it from that standpoint. You know, I think all of us who have found our names occasionally in the newspaper would like to feel that we had something.
Never happened to you, has it, Judge?
Well, but as I was telling my wife during this process, no matter how badly it turned out as far as the publicity, I think that, that the freedom of the press is essential to a free society. And she sort of looked at me because we were going through the midst of it, are you out of your mind? But I believe that, and I believe that even as I was going through it, and even as I am going through it. But I think what the court was attempting to do there was, of course, to balance the First Amendment rights, the freedom of the press as we know it, and to not have that in a way impeded by one's abilities to sue the media or to intimidate the media, and applied a standard of actual malice and struck a balance by protecting the rights of the individual with the standard of actual malice. That is something, of course, that one could debate, but I think it is demonstration, a clear demonstration on the court's part that the freedom of the press is important in our society. It's critical in our society, even though individuals may at times be hurt by the use of that right.
Do you see any need to change that standard?
I, at this moment, certainly have not thought about changing that standard and have no agenda to change that standard. I think the court is, my view, as I've attempted to express here, is that we should protect our First Amendment freedoms as much as possible.
When you were at the EEOC, you spoke often about preparing our young people for the high-tech jobs of the future, and you mentioned especially minorities. I totally agree with you, and I would hope that more and more government officials would continue to say the same thing, and more people in the private sector would say it, because I don't believe we're doing anywhere near enough. I also know that as new technologies come along, we look at some of the civil liberties questions they bring up. One scholar even suggested a 27th Amendment to explicitly extend civil liberties, including freedom of speech, privacy, and protection against unreasonable search and seizure, and apply it to these new technologies. Now, I'm not endorsing that proposal at all, but it raises the questions that come up all the time about how we interpret the Constitution in light of technologies that were totally inconceivable at the time the Constitution was written, some that were inconceivable 50 years ago even. Do you have any comments on the adequacy of constitutional protection for computer and new telecommunications technologies?
Senator, I think that perhaps some of the same questions were raised with respect to search and seizure, and certainly addressed by the court when telephonic communication became an important part of our way of life. And I'm certain many of the cases or many issues will arise as to tapping in the computer databases, as well as issues involving such things as caller ID. I have not explored all of those issues. I certainly have seen our laws, particularly in our constitutional laws, as moving and developing, and as those technologies move and develop. It certainly has done that in the past, and I would have no reason to believe it won't have that capacity in the future.
Well, we have talked to you about specific issues here, many times on civil rights, relations between the federal government and states, Roe versus Wade, a number of others. On some of the specific issues you have said is that you did not want to discuss them, or you had certain parameters beyond which you would not discuss them because they might come up again. Let me ask you then in the abstract, on just a basic sense of stare decisis, how you might go. Case comes before you have to make a judgment in deciding
whether you should overrule a decision. You feel that the case law that might otherwise control was wrongly decided. Now you have another case, perhaps on all fours. You have to decide, shall you vote to overrule the earlier decision? Tell me the kind of weight that you would give to these various points. How much weight would you give to the Supreme Court's acceptance of the basic principles of the case? I mean, their subsequent acceptance after they had decided the earlier case, the case which you happen to think was wrongly decided. How much weight do you give to the court's acceptance of the basic principles of that case?
Senator, it's hard to say exactly, precisely how much weight you would, in judging a case, give to a particular component. I think, though, that when you have a precedent that has been relied on in the development of subsequent Supreme Court law, it's not one that was simply there and has never been relied on by the court. But I think that you would give significant weight to repeated use of that precedent and repeated reliance on that precedent. I think that's very important.
You give weight also to changed circumstances. Suppose we've changed substantially, as a country even, since the earlier case had been decided. Is that something that can at least be considered or should be considered?
I think what the court does, and it depends on a particular case, Senator, is if a precedent or a rule becomes unworkable, the circumstances changed to a point that it's no longer a useful precedent. It's one that is not applicable. I can't think of one off the top of my head right now, but I think the court could revisit a precedent when it becomes unworkable.
What about the importance of stability and adverse consequences that might result from overturning a case that people had relied on up to that point?
I think what's critical there, Senator, is this, that one of the reasons in our case-by-case system of adjudication for having stare decisis is to provide for that continuity. And I think that continuity is a basis for the stability of our system. It's certainly a basis around which institutions can develop. It's a basis around which people can develop some sense of predictability in our system. It's a basis upon which I think people can react in a positive way to our system. I think that the continuity and the stability is important. And again, let me just add and underscore the factors that you're isolating here. And by saying this, I think that the burden is on those who would change a precedent to show more than simply that they disagree with the underlying opinion. I think there's that additional burden, which would include an analysis, certainly would include the factors that you set out here.
Absent changed circumstances, does time, a lapse of a significant amount of time, does that weigh heavily in such thinking, or should it?
I think that to this extent, and perhaps in this way, I think that in two ways at least, that the passing of time will certainly have some relationship to the manner, maybe not directly, but the way that the Supreme Court has used that precedent, whether it's cited that precedent over a long period, whether it's built a body of case law around that precedent. The other point is that over time, an important precedent could be a basis upon which or around which institutions develop and grow, expectations develop and grow. And I think that those will certainly be taken into consideration. So in that sense, I think time is important. But I add this, though, that there have been precedents in our time, for example, Plessy, which was overruled, which had been around for quite some time, and certainly I don't think there's any argument that that should not have been revisited, notwithstanding the significant time that it had been around. But I only use that as a caveat.
There, would you allow that in Plessy versus Ferguson that there was, of course, at least to some extent, in our society changed circumstances, or were there?
Well, society had changed somewhat, not totally. I think that sometimes we think that it changed more than it actually had, and that we hope that...
Some might ask if it's changed all that much since then.
Well, that's... some do ask rhetorically.
How do you feel?
Senator, the fact that I'm sitting here engaged in a discussion with you at a confirmation hearing for the Supreme Court of the United States indicates that there's some change. But throughout, there's been much discussion about my speeches and interviews, but you'd find a common theme running throughout them, and that is this, that there may have been changes, but there's still so much yet to change. There's so many individuals who are left out of our society who deserve and should have a central role or full participation in our society and all that it has to offer. And that's something that I believe in. It's heartfelt. It's something that I've reiterated over the years, and notwithstanding the changes, there needs to be more.
Let's go through all the different things we've talked about, change circumstances, what you said about the length of time that a case has been on the books, weight to be given to accepted, what a change might do, or overruling a case, what that might do to practice that may or may not become accepted practice. Then after you've gone through all that, what if just in your heart you look at that decision and say, I don't like it. I've read that decision, I disagree with it. Prescinding from all the questions of changed circumstances, time, effect on society, acceptance, or anything else, you, Judge Thomas, sit there, and if you've been confirmed as a Supreme Court justice, you sit there as Justice Thomas and you say, I don't like that case. I disagree with that case in my heart, morally, politically, emotionally, whatever, legally, whatever the reason is, I disagree with it. What weight does that carry as compared to all the other things we've talked about?
Senator, there is Justice Marshall's dissent in Payne versus Tennessee, I think, is a very important admonition. And that is that you cannot simply, because you have the votes, begin to change rules, to change precedent. That's not a basis for doing it. I think it's a very stern and necessary admonition to everyone, all of us who are judges. On a personal level, as a judge, I, at the end of a day, if I made a decision in a case that way, that willfully, I could not say to myself in the mirror that I have acted consistent with my oath and the way that I see my obligations as a judge. I do not think that it is appropriate to just simply say, as a judge, this is the way I feel, and that overrides everything else. I don't see where we have order to our system, and I certainly don't see where that's consistent with the conduct, with the discharge of my obligations under my oath as a judge.
Thank you, and Mr. Chairman, thank you. I do not, well, I have many more questions, but I do not anticipate going through. Again, Judge, I commend you for being here, and I hope you won't think it inappropriate if I also commend your wife and the rest of your family who have been here. I mentioned to your son last week that I admire his aplomb and his ability to stay there, where you would be pleased in his response of why he was willing to do that for you. And so, Mr. Chairman, thank you very much. Thank you, Judge.
We will break for 10 minutes.
we are gonna break for longer than 10 minutes. 7:30 on a Friday. I gotta think about wrapping it up because there's another 2 hours of this part of day 5, and there's another 2 parts. I do believe we could just go back. I'll show you. And day 5, part 3, and part 4. And then we get to day 6, and then day 7 and 8. Those are friendly witnesses. It's like references for when you're applying for a job. It's not till later. And this is kind of funny if you're looking at this. Is a life term good idea? I don't know. I like to think that these things that the founders put into place are good ideas for the most part. I don't want to go like overhauling anything. That's just I try to be conservative. I'm a Peterson student, so to speak. If I can't be the smartest guy in the room, I try to be the most conservative guy in the room. I try. And it doesn't always happen. But the point is that if I'm being conservative, then I'm not trying to go ahead and like rewrite the Constitution, right? And thank you. I can't, I've tried to do it without Vivaldi. It's like a love-hate relationship. I miss it when it's not on. And it's sometimes like, okay, I can't do any more Vivaldi. That's how I know it's time to end the stream. We got some good topics that we covered here, from Chevron deference, which was just more or less overturned in the Loper case. We talked about Lopez and the Commerce Clause, which that was when the government tried to regulate guns in a school zone using the Commerce Clause in the Constitution, and it didn't really hold up because that's not an issue of commerce, of interstate commerce, really. Life term is the worst system except for all others. Here's my thing is I really want to see term limits in the legislative branch before the judicial, right? Maybe we won't need it. Maybe we do. I like how they all the pendulum swings, right? You get new House of Representatives every 2 years. That pendulum swinging fast. Senate slower. You get 6-year terms. President's somewhere in between with a 4-year term. And then you have the judges, which is a nice slow pendulum swing. And the system's supposed to work like that and move slowly. If it was fast all the time and just new people, new things, new ideas, that might be too progressive, I don't know. I don't have the answers, but that's why we're watching. I like to hear what other people have to say. I like to hear Thomas's philosophy, and I'm eager to go back and get to Scalia too. I've read his books, so I have an idea. He's an originalist. He's like the originalist almost. But you can see that next week, we're going to be going. You see, confirmation hearing day 8, and then we get to the second hearing, which gets into, you see the view count jumps up to 7,000 views. They get 81,000 people viewed day 1, part 2 in the second hearing. That has to be Anita Hill, or maybe grilling. Yeah, you can see her in the thumbnail right there. And then day 1, part 3. Yeah, and then day 1, part 4. You get Thomas. It's okay. I'm eager for this too. I was trying to play it cool, like maybe I'd be invited to a cocktail party with Justice Thomas, and he wouldn't want me to cover the Anita Hill. I don't think I'm getting invited to that cocktail party, okay? So, I think we're going to cover it. Okay. Anything else, chat? I know, Commerce Power is... the whole thing is overbroad. Everything is overbroad. Everything they use is just like, commerce or... what's another one that they like to... The health and welfare, the general health and welfare they like to do on that. Where else do they get their powers from? Oh man, totally abused. And then you have the federal. This is why I like the Chevron, the overturning of Chevron in the Loper decision, is because where the federal government once had all this, the agencies specifically can kind of like legislate with a magic wand and say overnight, this is illegal. Like so, ATF can say like bump stocks are illegal without any legislating, no votes, no citizen input. Just they made that rule. That was what we called Chevron deference, which is where the agencies had a lot of power to where there's ambiguity to make the rules, and the courts said, "Hey, well, that's not checks and balances. We're supposed to be doing that kind of thing." So that has we'll see how it scales. It seems to, in theory, severely scale back the federal agency power. So, am I a real person? Dave, please tell my friend you're a real person. I think I'm a real... It depends. Me and Mrs. Dave the lawyer have this conversation. You know, if simulation theory is real, am I a real I don't believe in that. That's smart people. When they have anxiety, they go on simulation theory. I am real. I am an attorney at law. And I really appreciate everybody joining me today. Like I said, some attorneys cover the criminal cases. There's a lot of criminal cases. They're salacious, right? And those, you know, the celebrity divorce cases or defamation cases get a lot of play. But there isn't a lot of the meat and bones of the legislative or the judicial as far as coverage of the Supreme Court and Congress. Not a lot. So I thought I thought you were enlightened. It appears you're just mega thug. Maybe a MAGA. I'll take a mega thug. Mega Man. One of my faves. Simulations are real as a physics major. Oh, no doubt. I'm mayor of my own Sim City. You know what I mean? I am the city attorney in my own Sim City, in my imagination. So. No, I know. It's a debate. I like it all. I like all the theories. I like to lay there at night and look at my ceiling and think about all the ridiculous things that we might be. Just like the next guy. But I had a great time. She's making fun of you, saying, "You think you're a real person? I wonder if she's a real person." I don't know. What time do I usually go? So yeah, I try Monday through Friday. It's been different. Let me start off by saying that. I took another bar test. I was trying to get another admission. We'll see. It takes about 2 months to get those results back. I slowed down my practice. I haven't gotten my caseload back up to where it was. So what I'm trying to say is I'm trying to figure out my schedule. I'm reaching out to like other YouTube lawyers to see what they're doing. Please tell me. I don't know if there's like if there's a right way to do this. I just know that I don't know what that balance is. Whether it's 20 cases or 10 and, streaming, I don't know. So, am I a real person? You got me questioning. Exactly. Yeah, I like to think we're real. I like to think simulation theory is just for people who are too smart. But, physics major gunslinger media. That sounds like you're sounds like you're too smart. I'm just kidding. I tried to read the Bostrom book, Super Intelligence, and I couldn't get through it. He's too smart. He's just too smart. So, that's all I got for today. We'll start again, I think, probably Monday, unless I get super bored over the weekends. We might get back into it, but I got the kid's birthday tomorrow. Yeah, the littlest one. So, probably not this weekend. See you Monday. With the Anita Hill of it all. Should be good. Check back in. Don't forget to subscribe, like. All those things help. Yes. Love you guys. If you're still here, Matt. Matt is allegedly still here. Is Brandy. I don't know if you're still here. But I'm gonna... Stacy never came today. What are you gonna do? Jacqueline. I'll see ya. Yes, the little one. I think we're doing a bounce. Some bouncing. One of those places. All right. Bye, everybody.